right now. They're just checking. Good morning, Justice Ramalingam. Are we audible, sir? Justice Ramalingam has already logged in. He will, I think, come after 10 minutes. Meanwhile, you can do your AV. Thank you.
Hello, sir. Good morning, sir.
Good morning. Good morning.
Yes, sir.
Okay.
My
So,
voice is clear, sir?
yeah, your voice is absolutely clear. Thank you.
Okay. Thank you, sir.
So, we'll start at 10 a.m. exactly,
Okay, sir.
right? And I hope you have the program sheet also. So, AV is perfect. Voice is quite clear. It's fine.
So
Thank
your
you.
voice is also clear, sir.
Right. Chalo. Thank you, Ji. We hope that if Justice Ramalingam could have come physically, that would have been amazing. But nonetheless, virtually is equally good.
Yes, sir.
Where am I? You don't tell me, and how will I go back and then change it? Nothing. Nobody.
Justice Ramalingam, good morning, sir. Good morning.
Good morning.
Okay, just checking your AV, it's perfect. Great. So we'll
What
start.
else happening? It's 10 o'clock. You said it will be on time.
We'll just start in 2-3 minutes, sir. Just a second.
But first is a at the end, you cannot. So you first ಆರಂಭಿಸ್ತೇವೆ ಅப்புறம் இந்த bullet point.
Good morning, ladies and gentlemen. Welcome to PHTCCI's conference on corporate restructuring, role of NCLT and NCLAT. We were just waiting for this inclement weather to settle, but I think Indradev is very, very humble to us, and from the last, I think, 3 days, it has been continuous drizzling. Great. In fact, we have got all the northern part of India. So I'll request the dignitaries for the inaugural session to kindly come on the dais. I'll request, first of all, Dr. Ashok Kumar Mishra, Mr. PSN Prasad, Dr. UK Chaudhary, Mr. Pradeep Multani, President PHTCCI, Mr. GP Madan, and Mr. Abhishek Anand to kindly come on the dais, please. So we are also joined with Justice Ramalingam Sudhakar. Good morning, sir, and welcome.
Good morning. I'll be on the screen, I think.
Yes.
Good morning, all of you.
Good morning, sir. Good morning. So we are waiting for Dr. Mishra. Once he comes, we'll start.
Pure white. Pure white fluffy. This only the client ಯಾವಾಗ followers the senior first friend car accident national company ನಮ್ಮ client ಸರ್ ಯಾರನ್ನೇ ಸಿಗದ ಆಲೆಗಳು ಎಲ್ಲ ಬಾಯಿ சிங்கப்பூர் பெரிய அமெரிக்கா போயிட்டான். நல்ல மனுஷன் கெட்டனார். Yes, sir. What's the difficulty? What's holding up? Compare. Why is it there? And only 60 grams. Pattern is different in both. Yes. So if there is a mistake, how do you read the 66% into that?
Thank you, sir. So can we have a huge round of applause for Dr. Ashok Kumar Mishra, please? Thank you. So before officially starting the program, may I request everybody to kindly rise for the national anthem, please.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंग विंध्य हिमाचल यमुना गंगा उज्ज्वल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you. May I request all the dignitaries to kindly join us for lighting of the lamp, please. Sir.
And shadow participation in the ability, how do you reconcile 78%? How do you reconcile 78% more with 66%? And what happens to the shareholders? What happens to shareholders? Important point here. Chief and consumers. Can be granted under this scheme.
So PhD Chamber of Commerce and Industry
Income
has
tax compliance
a very important conference on corporate restructuring role of NCLT and NCLAT with new judgments that we are seeing every day, which are actually changing the total ecosystem of the IBC regime. So in order to understand the nuances, nuts and bolts of this conference, we have curated 3 important sessions wherein domain experts will give their own viewpoints in terms of making us understand the dynamics of corporate restructuring. So without any further ado, I'll request Mr. G.P. Madan, Chair of NCLT and
Please,
IBCL
yes, no?
Committee, PhD Chamber of Commerce Industry, to kindly come here and give the theme address, please.
Thank you, Dr. Jatinder. Honorable Member Technical National Company Law Appellate Tribunal, Dr. Ashok Kumar Mishra. Honorable Chief Justice Ramalingam Sudhakar, President National Company Law Appellate Tribunal. Sir, on your behalf, we have lit the lamp also.
Thank you. Thank you very much.
Honorable Member Judicial National Company Law Tribunal, Mr. P.S.N. Prasad. Dr. U.K. Chaudhary, Senior Advocate and President National Company Law Tribunal Bar Association, which was earlier Company Law Tribunal Bar Association, Company Law CLB, sorry, and past President, Institute of Company Secretaries of India. Mr. Multani, President, PhD Chamber of Commerce and Industry. Dr. Jatinder Singh, the organizer, the main chief organizer of this entire event, his team members, and my colleague on the dais, Mr. Abhishek Anand, and fellow friends, invitees, delegates, ladies and gentlemen, good morning to all of you. I welcome you to this conference on corporate restructuring role of NCLT and NCLAT. Friends, many of you might be remembering that provisions with respect to National Company Law Tribunal were introduced first time in the Companies Act 1956 through Companies Amendment Act 2002. Now we are in 2022. At that point of time, it was decided that BIFR shall be abolished, SICA shall be repealed, CLB will not remain there, entire jurisdiction of CLB will shift to NCLT. High Court jurisdiction with respect to M&A and with respect to winding up will also be shifted to National Company Law Tribunal. However, those provisions could not see light of the day because those provisions were challenged by Madras Bar Association. The matter ultimately went up to Supreme Court, and Honorable Apex Court way back in 2010 decided in favor of the constitution of NCLT and subject to following certain guidelines which were laid down by Supreme Court in the year 2010. And at that point of time, the road was clear for the government to constitute NCLT. But in the meantime, the government was in the process of repealing the old Companies Act and bringing about a new company law. And ultimately, we had Companies Act 2013, which replaced Companies Act 1956 in phases. And now after Companies Act 2013, again, there were provision of constitution of NCLT, but that also got delayed because the provisions with respect to constitution of NCLT were again challenged before Supreme Court. And again in May 2015, Supreme Court through its judgment paved the way for constitution of NCLT subject to following those guidelines which were laid down by Supreme Court in 2010. After 2015, now the government started the work of constitution of NCLT. And in the meantime, the government also decided to bring about a new legislation, that is insolvency and bankruptcy law. And ultimately on 28th May 2016, this legislation became reality. President signed the bill and it became Insolvency and Bankruptcy Code 2016. And within next 4 days, on 1st of June 2016, government constituted NCLT and NCLAT. Actually, all these decisions were taken with a view that because of these two major changes of constitution of NCLT and Insolvency and Bankruptcy Code, we will have a better rating in the ease of doing business of World Bank rating. However, in the 2016, that couldn't happen. Even because of these two changes, we moved from 131st place to 130th place. Just 1 point jump. Reasons were very simple. That because 1st June actually is the cutoff date from the World Bank for ease of doing business ranking. And 1st June 2016, NCLT was just established and IBC became a reality. It was not implemented. But very next year, after 1st June 2016, we had a number of NCLT benches throughout the country, and we saw IBC being implemented on 1st of December 2016. And because of these two major changes, we saw a whopping jump of 30 points. And from 130th place, we moved to 100th place. And very next year, again, there was a 23 points jump. That time it because of GST. Now, once this IBC and NCLT became reality, only after constitution of NCLT, the provisions with respect to, some of the provisions with respect to Companies Act were also amended. Some of the provisions got deleted. If we see the combined reading of SICA, IBC and Companies Act, what we see that the game still remains the same, but the rules of the game have now changed. The word sickness has been replaced by the word default. The revival or rehabilitation has been replaced by the word resolution. And winding up has been replaced with the word liquidation. Now we have liquidation under IBC and compulsory winding up under still Companies Act 2013. But these changes have actually changed the landscape of our Indian corporate sector, our Indian economy. Now, M&A jurisdiction is with NCLT. Liquidation, including voluntary liquidation under IBC, is with NCLT. Entire company law board jurisdiction, including operation and mismanagement, has come to NCLT. Actually, to begin with, NCLT was constituted under the Companies Act 2013 for the purposes of Companies Act. But when IBC came, NCLT was termed as adjudicating authority under Insolvency and Bankruptcy Code 2016. So the burden which was there with NCLT with respect to company law only under Companies Act, it became doubled, rather more than doubled through this IBC code. And if that was not enough, in the meantime, what happened? The government struck off more than 4 lakh companies under Companies Act 2013 under Section 248. And then there is a provision under the Companies Act 2013 that an appeal against this order of the NCLT can be appealed before NCLT only. So thousands of appeals were filed under Companies Act 2013 against the orders of ROC for striking off of the names of the companies. That added to the burden. All this was going on. We had COVID in 2020 and 2021. So, and all of a sudden, the work mounted like anything. But still, I must confess, I must share with you that all the NCLT benches are trying their level best to come up to the expectations of the stakeholders. Though many stakeholders say that M&A has taken a back seat, but if you see the NCLT benches, the way they are overburdened, the way the workload is there, majority of the members of the benches are sitting pre-lunch in one bench and post-lunch in another bench. I'll not say they are trying their level best, I'll say they are doing more than their best. And that is the reason you see that even on this Saturday, honorable members of NCLT, honorable President NCLT, honorable technical member NCLAT are here with us. Honorable President NCLT is still there, and I have come to know that 11:30 he has convened a meeting of the members of NCLT. You see, that is a commitment, that is a dedication, that is a devotion. And I'm very sure the moment we have the complete bench strength, I'm very sure all this backlog will be cleared very soon, and we will see that all M&A cases and all resolution plans will be passed, if not within days, within months. Today, friends, we are going to discuss all these issues relating to corporate restructuring, whether it is M&A or whether it is a resolution plan, because according to the resolution plan is also a corporate restructuring activity. Because if you see the preamble of the code, IBC 2016, that is also using the word the restructuring, reorganization. That does not talk about liquidation. So reorganization under IBC is also a corporate restructuring activity. So we will be discussing this. Then we'll be discussing the scheme of operation, the scheme of compromise or arrangement under section 230, which can be applied at the time of the liquidation of the corporate debtor. And last but not the least, we are going to discuss the merger and acquisitions also under Companies Act 2013 today. With this, I conclude my remarks, opening remarks, and I welcome all of you. I welcome all the dignitaries sitting on the dais, and I welcome President NCLT, Honorable Justice Sudhakar. Thank you very much.
Thank you very much, sir, for the theme address, and you have, in fact, in essence, have given the entire ecosystem of IBC, NCLT, and NCLT regime. Thank you very much. Now, with this, I'd like to invite Dr. U.K. Chaudhary, Senior Advocate and President, NCLT Bar Association, for his deliberations for the august audience, please.
Honorable Dr. Ashok Kumar Mishra, Member Technical, NCLAT. You know what it stands for. I need not to take the full name. Honorable Chief Justice Ramalingam Sudhakar, President NCLT, Guest of Honor, Shri P.S.N. Prasad, Honorable Judicial Member, NCLT, Shri Pradeep Multani, President, PhD CCI, my colleagues, Mr. Madan and Mr. Anand, Chair and Co-Chair of the PhD CCI, NCLT and IBC Committee, ladies and gentlemen, during the next few hours, you are going to have a lot of discussion on the micro issues relating to the role of NCLT and the NCLAT in the restructuring. I have no intention to discuss those micro issues. You will be visited by a number of experts, including the two who are already sitting here on the dais, and the honorable members who will speak to you also about the micro issues. As a president of the NCLT, I think it's my duty to share few of my thoughts about the macro issues about the role of NCLT and the NCLAT on the restructuring propositions. Now, before I take up one each by each and share my thoughts with you, let me tell you that there are three major issues which I will discuss with you in a very short span of 5 to 7 minutes. The one is that if any purposeful and meaningful role is to be played by the NCLT and the NCLAT in the restructuring propositions placed before them, either under the Companies Act 2013 or under the Insolvency and Bankruptcy Code, the one thing which is more important is that we must have a proper structure and the restructuring of the NCLT itself. I'll tell you that why it bothers me today. When we were having rounds and rounds and rounds of our visits to the NXC in the Parliament, I particularly representing PhD CCI in that expert committee at that time, giving a memorandum to the select committee of the Parliament on the provisions of the amendment, first in the Companies Act 1956 and later on in the Companies Act 2013 itself. I also happened to be in the committee of the delegation of the FICCI, Institute of Company Secretaries of India, and the Institute of Chartered Accountants of India. So I personally visited at least 4 times that NXC in the Parliament and discussed and debated that if any important role is to be played by an institution which will come to be known as the National Company Law Tribunal, and its appellate authority. Itself, the structure is very important. So at the behest of the number of representations which were made, it was promised that under the Companies Act 2013, as and when the National Company Law Tribunal will be established, it will have a sanctioned strength of 63 members. And that was when nobody knew that there is going to be insolvency and bankruptcy court. So 63 members were required only to deal with the various propositions and the entire jurisdiction of the Companies Act 2013, which included the jurisdiction which were to be the appellate authority of the various decisions of the Ministry of Corporate Affairs, the ROC, and the regional director, the entire transfer of the jurisdiction of the High Court to the NCLT, and the jurisdiction which was being exercised by the then Company Law Board also to be transferred to the National Company Law Tribunal. 63 members. When eventually we saw the light of the day on 1st of June 2016, that suddenly the notification came, we were given only 28 members out of 63 members to deal with the company jurisdiction. And then to our very pleasant surprise, another important jurisdiction was given to the NCLT, that was Insolvency and Bankruptcy Code. And the entire litigation exploded in the face of the NCLT. And of course, the professionals which were going there. The number of cases suddenly jumped 5 times more than what they were under the Companies Act. So we were expecting that at least 63 members the government will give us. What happened? Another 27 members came in the 3 tranches, and the strength went to 45. That 45 did such an excellent work in the NCLT that eventually this was the most happening corporate jurisdiction recognized in the Asia at number 1 in the entire of Asian continent. This was the achievement done by the NCLT with 45 members. You please imagine that if at that point of time even 63 members were given, whereas in my expectation, if you expect that there will be 100 number of cases in the Companies Act and 63 members will be dealing, but suddenly the cases become 500, I was expecting that the numbers will multiply, the Companies Act will be amended, the 63 strengths will be at least go to 150. But this did not happen. On the contrary, what happened? That today we have a situation where we have a bare minimum of 28 or 29, I'm not exact number, but 28 or 29 maximum. And I know for sure, it's in my personal knowledge, that all honorable members are sitting up to 6 o'clock, 6:30, even sometimes 7 o'clock. The Honorable President himself is taking 3 jurisdictions in the same day, dealing with 3 benches. Each bench is dealing with two jurisdictions or 3 jurisdictions. I cannot expect that more hard work is being done by any tribunal or even any High Court or even the Supreme Court of India as this tribunal is doing as of now, trying to fathom with the immense proposition of the cases with only 28 members and dealing with 28 benches. You cannot expect more. I'm honored to have my members here and some of them who are listening to me. I'm truly honored and indebted at the bottom of my heart by the hard work which is being done to keep this jurisdiction alive and to do their best. So one, I wanted to, from the PhD CCI, at least I wanted to convey to the government of India, please give us, if not more, at least the sanctioned strength of 63 members. And you will see that what wonder this tribunal will do, which in my opinion is one of the most important tribunal in the country today, not only the important in the terms of the economic development of the nation, but also of the welfare of the society, because ultimately the society is being served by the trade and industry. And the trade and industry need a restructuring, and the restructuring is being looked after only by the NCLT today, either under the provisions of the Companies Act 2013 or under the provisions of the Insolvency and Bankruptcy Code. The second point, which is also of a macro level, is the speed. I have seen myself that when there were 45 members dealing with the Insolvency and Bankruptcy Code, the things were getting resolved under the IB code within a period of sometime 60 days, sometime 90 days, and only the most complicated cases went to a year or 2 years or 3 years. That is right up to the Honorable Supreme Court of India. That speed is being maintained today. But what do you expect if a member has to take 3 jurisdictions in a day? That he sits from 10:30 to 1:30 in one jurisdiction, from 1:30 to 4 o'clock in another jurisdiction, and from 4 o'clock to 6:30, and I do not know, at 7 o'clock in the third jurisdiction. What do you expect the tribunal members to do? They are also human beings. There are only 24 hours. And if I take the waking hours, there are not more than 16 waking hours. Everybody need at least 7 to 8 hours sleep. So what do? Therefore, the speed has become casualty. The very objective for which the jurisdiction of the High Court was transferred to the National Company Law Tribunal, it has become a casualty, not because that there is any dearth in the jurisdiction of the NCLT, but because the required strength of more than 63 members is required to see that wonder, that what wonder will be done by this tribunal if it has the required strength of 63, or in my expected requirement of not less than at least 120 members to deal with the 28 benches. The fourth, which you must have seen, that the jurisdiction is being exercised by the tribunal either under the IB code. At the micro level, you all know what are those judgments which have settled this jurisdiction over a period of almost 5.5 years by the Honorable Supreme Court in the various judgments, including the last one few of the SR Steel, Ghanshyam Mishra, and Rainbow and Vidarbha. You all know at the micro level that these judgments are being done. But I'm not that what the Honorable Supreme Court is doing. I'm dealing that this speed is still being maintained, and the role of the NCLT as an umpire can still be very meaningful, very purposeful, and it can do a wonder in the jurisdiction of the restructuring, whether it is under the Insolvency and Bankruptcy Code, or whether it is under the jurisdiction of the Companies Act, which you know various sections like restructuring, which is coming under the jurisdiction of 230, 231, 232, or even sometime a restructuring taking place under the jurisdiction which is omnibus with the powers of the Honorable Supreme Court under Article 142, that is 241, 242, an equity jurisdiction of the tribunal. This is the role of that umpire that which the tribunal is playing today, and it is, in my personal opinion, there may be a difference of opinion, is being done wonders. It could not have been done better anywhere in the world what is being done by the tribunal. I therefore beseech my members and the litigants that please bear with some of our shortcomings as a professionals and the hard work which is being done by the tribunals. Bear with them. As and when the government listen to us, give us the strength of the 63 members, that speed will come back, that umpiring will come back, the game will become fair, the game will become justiciable, the game will become equitable, and I assure all of you that you will see the more wonders of this jurisdiction becoming the most important, not only in Asia, but in the world. Thank you very much.
Thank you very much, sir, for a very, very strong and dynamic deliberation. In fact, you would definitely spoke from your heart. Thank you very much. And before I invite Mr. PSN Prasad, Member Judicial NCLT, I'll request Mr. Madan to kindly introduce Mr. PSN Prasad. Mike.
It's my privilege to introduce Dr. P.S.N. Prasad, Judicial Member, National Company Law Tribunal. His profile is very long, but I won't take much time. He has remained as legal advisor in Reserve Bank of India as Chief General Manager before he joined NCLT as Judicial Member. He is pursuing his doctorate in law from Mumbai University. And when I was going through his profile, I saw that he has remained throughout his career since childhood. He has remained a meritorious student. He has got over 3 decades of experience in the field. He became a member of Andhra Pradesh State Bar Council way back in 1987, I think. 37 years, I think, yeah. 35 years. And after his graduation in law and practice at Visakhapatnam District and Session Court, along with this entire experience, he has got to his credit a number of articles, number of training sessions, teaching sessions, and he has a passion to be in academics also. Ladies and gentlemen, please welcome Mr. P.S.N. Prasad, Judicial Member NCLT.
Honorable Justice, Honorable Chief Justice Sudhakar Ramalingam, our President of NCLT, and Sri Ashok Kumarji, yes, Ashok Kumarji, Technical Member, and other dignitaries on the dais. It is true that we are discharging the role of an umpire, but still we are with a mind of true catalyst and a judicious umpire. And as far as both NCLT and NCLAT are concerned, we both act as generally the facilitator of the system. Facilitator of the system with prudence so that the proposals whichever that come, either restructuring or otherwise, they sustain in their long run. So in fact, our role is a true catalyst and a judicious umpire, not mere umpiring. Mere umpiring requires probably a third umpire. Since we discharge the role of judicious umpire, in fact, very less occasions where third umpire intervention may be required. And see, as the mother doesn't neglect her 2 children, one eldest child is company law for us. The second child, which has come later, is IBC. As mother takes care of both the children, we do, in our dispensation of delivery justice system, take due care and caution and weigh both the matters by facing them. I tell you from our court experience what we do. Few days we put company law matters from serial number 1 onwards so that early hearing will be there. Few days we put IBC matters little priority so that they will be heard first. And as far as the restructuring is concerned, in this restructuring itself, realignment is also involved. The realignment is an easy process than that of the restructuring. When a restructuring proposal comes, whether, as our earlier speakers have rightly said, it may be a CIRP under IBC, or an realignment, we can say outright purchase of an organization can be a straight example of a realignment. Realignment in the management of the company. As you all know well, restructuring is in fact a techno-economic concept. It is not. This techno-economic concept is translated in terms of law. See, traditional approach of law is a body of rules and regulations applied and recognized by the administration of courts in the delivery justice system. But modern concept of law has been totally changed. Today's concept of law is a true representation of the socio-economic, technical, political, and technological conditions of the country, and the country's intellectual capacity in addressing such problems. Let us take example of IB Code. It is to meet and address the economic crisis of taking longer duration of time in resolving the insolvency. Earlier we had Presidential Towns Insolvency Act of 1920 and Provincial Towns Insolvency Act of 1909 and certain provisions relating to the special statutes like company law where liquidation provisions are there. And certain schemes like BIFR have been initially come as an institutional mechanism, later on given the shape of law, but still ultimately they did not give the material results. Therefore, this new law of IBC has come. This is an example where we say that the traditional concept of law has been totally changed. Like that IT Act. IT Act has come because of the technological problems which this country has to address. So what I'm trying to say is, now law is more flexible. Law is more flexible and law is more focused, oriented towards addressing the socio-economic, technical and political problems also. There are certain enactments which takes care of, suppose anti-defection. It is a political, though it is a legal instrument, still to safeguard the political harmony. So like that, whatever the laws we are having today, these laws, we the members of NCLT, we always feel that law has structured in such a way that it facilitates the strength of the economy. So our approach also, we always try to be a true catalyst and facilitator with judicious approach. See, you almost all of you know about various provisions and NCLT background and all. So I am not touching. I only want to say what, as a member of NCLT, I look at. I want to share what I look at. And as our learned advocates who are here, they know very well, we always try to see the proposal on its structural merits. And once the merit of the proposal is in compliance with law. There are days on the same day in the open court we have dictated the order and disposed of the matters. Another important issue is, as far as striking of the companies are concerned, when an application is made under section 252 and around, we immediately try to know whether the striked off organization is in the interest of continuing its business activity or not, and whether it is capable of conducting the activity if the company is put on rolls again. These two criteria we keep it in mind. There are cases where we asked the applicants or appellants to furnish tentative business development plan for the next 5 years. See, they were not doing business for last 2 years, but they have earlier done good business. And their earlier financial statements reflects that they have done considerable role in the society. So we want to give them another opportunity. So I always suggest you give us a tentative business development plan, which can speak of itself that you are keen in doing the business. When that satisfies, with other requirements taken into account, whether the company is basically law-abiding company or not, whether it is tax compliant or not, only small basic requirements see and put the company on track and infuse life in it. There are cases where we have dictated the orders on the day when the proposal is perfect, not even reserved. In the open court itself, we have dictated. And there are cases where we have prima facie rejected and asked them to strengthen their proposal. As far as this 230 area is concerned, the vision is to see, we always believe the shareholders are the best judges how to run their business. We don't want to come or become a hurdle. When a shareholder comes forward with a proposal that he will be able to better do his business, either by merger or by demerger or by amalgamation, whatever way he plans. And there we give all exemptions, and wherever they meet the statutory requirement, we never compel them to conduct the meetings. We dispense the meeting of the stakeholders, shareholders, and the creditors, and encourage them to become a good business giant. And as far as the resolution plans are concerned, we are cautious, because the Supreme Court also says the resolution plans have to be scrutinized very carefully. Now the concept day by day is changing. What has been said by IBC is unsaid. That is becoming sometimes a problem. How to bring in harmony between the judicial wisdom and statutory provisions. That is the toughest task. Different levels of judicial bodies gives if different decisions, and statute pulls us in the other direction. Which supremacy has to be taken and which supremacy has to be upheld? There we are trying to have an harmonious approach. There we are trying to have a very harmonious approach, so that wherever we say that we don't reject your plan, but what is to be complied with now for as per latest law, you comply that and come with modification or revision to your plan, or withdraw the present plan and come with a revised plan. See, the responsibility of NCLT and NCLAT is day by day increasing. Day by day increasing. Because not only a particular law we have to see, all these eminent advocates come with different laws and try to apply to a particular situation the laws other than IBC and company law. There also we have a problem. There also again we have to see which law has to be predominantly upheld. Though section 238 of IB code says that IB code has overriding effect on all other laws, still, since you have all other laws weapon in your hand, you can't go in high speed. There also you have to apply judicious mind by seeing what will be the repercussion if the overriding effect is straight away given. If the overriding effect adversely works to the system, then we will try to think the other way. So I better volunteer one or two questions because I will be moving now.
We'll have Q&A at the end, sir.
Okay. ठीक है. Thank you very much. And I wish you all of you for very patient hearing, and also for PhD Chamber of Commerce, more particularly the President and our NCLT and NCLAT core members, and Dr. Chaudhary and Ashok Kumarji for affording this opportunity to me, including my President, who is entirely witnessing this today's seminar. And I thank you all once again. Thank you very much.
Thank you, sir. Thank you, Honorable Judicial Member, Mr. P.S.N. Prasad. Sir, as you said very rightly, I'm a witness to this, that though you being a hardcore banking regulator, but when your orders and judgments are pronounced, you have not given any undue favor to the financial creditors or to the banks. All these your orders and judgments have been on merits. Now I invite Mr. Pradeep Multani, our worthy President of PhD Chamber of Commerce. Thank you, sir.
Thank you, Mr. Madan. A very good morning to everyone. Dr. Ashok Kumar Mishra ji, Member Technical NCLAT, Honorable Chief Justice Retired Shri Ramalingam Sudhakar ji, Mr. P.S.N. Prasad, Member Judicial NCLT, Dr. U.K. Chaudhary, Senior Advocate and President NCLT Bar Association, Mr. G.P. Madan, Mr. Abhishek Anand, Chair and Co-Chairs of PhD's NCLT and IBC Committee. On behalf of PhD, CCI and my own, I would like to welcome and thank our guests of honor, keynote speakers and other eminent speakers, and also the distinguished delegates who have spared their valuable time for timely conference on corporate restructuring, role of NCLT and NCLAT. Let me just mention a few things about the PhD chambers. PhD chambers were established in 1905. We are 117 years young. We are present in 16 states, 3 union territories. We have buildings like the one we are sitting in Delhi, Chandigarh, Lucknow, as well as Jaipur. And the other states we have got offices on rent. We reach out to more than 150,000 companies. Our main job is that when our Honorable Prime Minister says, make India USD 5 trillion economy, how do we achieve that? Whatever problems which are there, and today is a very, very important session because we strongly feel we need timely justice. That is the biggest impediment for us, for the Indian industry to achieve its goal. because whether it is any, I would say any department, I'll just take the name of GST or income tax or anything, the major problems the industry is facing, because when the officials know that the decision taking will take, 10 years or 8 years or 7 years, it becomes really difficult. So today, agenda is very, very important. I will be very, very brief because we would like to hear the experts. I would like to hear the experts also. You see, as a representative of an apex industry chamber, I would like to put forth some of suggestions that will benefit the corporates going for restructuring, resolution or liquidations to a great extent. Mediation should be introduced for out-of-court settlement of disputes in a speedy and cost-effective manner. Introduction of a single window for all company law related matters. Increasing the number of benches and strengths of members at all benches. Creating world-class infrastructure for all the benches. Discouraging malicious and frivolous applications. The need of the hour is to have a healthy market environment that facilitates corporate restructuring and mergers. It is imperative for regulators to have a proactive engagement with stakeholders to evolve systems and practices that balance facilitation and enforcement. We are thankful to Honorable Chief Justice retired Mr. Ramalingam Sudhakar for inviting PhD CCI in the National Company Law Tribunal Colloquium, NCLT, The Road Ahead, at Hotel Lee Meridian on 26th and 27th March 2022. We gave some important recommendations for creating enabling environment for MSMEs under IBC regime. I am sure that Honorable NCLAT Chairperson, Mr. Justice Ashok Bhushanji, who is ably supported by members like Mr. Ashok Mishraji and also dynamic Honorable President NCLT, Chief Justice retired Shri Ramalingam Sudhakarji, who is duly supported by competent members like Shri PSN Prasadji, will take NCLAT and NCLT to greater heights. I would like to congratulate PhD CCI's Insolvency and Bankruptcy Committee for coming up with this pertinent theme to provide a platform for deliberations that would be instrumental in addressing the issues faced by stakeholders under IBC. My congratulations to the chair and co-chair. I would once again like to thank all speakers, delegates, and invitees for the valuable participation in today's event. Thank you, Jai Hind, and God bless us all.
Thank you, sir. Thank you, Mr. Multani. Sir, I'm really thankful and grateful to Honorable President Ramalingam Sudhakarji for inviting us in PhD Chamber of Commerce and Industry in the colloquium held in the month of March, as you just mentioned. Friends, now it's the turn of our guest of honor, Honorable Justice Ramalingam Sudhakarji, who we all lawyers love and give greatest of respect. And it's not only we give love and respect, in turn we also get rest of the respect and love from our Honorable President. And I was wondering what is the reason for this. The reason I came to know today morning only that Honorable Justice was born on Valentine's Day, the 14th February 1969. Sir joined this National Company Law Appellate Tribunal as President in November 2021. Before that, he was Chief Justice of High Court. He has a number of landmark judgments to his credit, particularly in the field of environmental law, infrastructure, motor accident claims, and enforcement of foreign awards. Along with being a judicial member, a judge, justice, he has been an able administrator also. When I was going through the profile, I came to know that he has worked very hard for the building of Madras High Court, and he was chairman of the Heritage Committee to refurbish the 125 years old Madras High Court Heritage Building. Same enthusiasm we are seeing here also. Whenever we from the bar have met him and gave our suggestions, and we saw that many of suggestions have been implemented. Those who are regular lawyers to the NCLT, they must have observed even day before yesterday, the new canteen has also been inaugurated by Honorable President. So whatever requests or demands we have been raising, all those demands have been are being accepted by Honorable President. And this is despite the fact, as Dr. Chaudhary said, that many a days he's chairing not only, presiding over not only 2 benches, but 3 benches also. I remember only 2 days ago when he came back from Chennai. From Chennai, he was handling Chennai bench as well as the principal bench. Very next day, he was presiding over principal bench physically here in Delhi at 10:30 during lunch times around 2 o'clock. The moment he entered his room, I took this liberty that before he has his lunch, I went to him and I requested to be present here today. Though his schedule was very, very hectic, but immediately he said yes, that he'll be here, if not physically, virtually. We are so thankful, so grateful to you, sir, to be with us in this inaugural session. Friends, we the lawyers want to remain seated in his courtroom, provided space is there. The reason being, no doubt, the discussion which is happening there, but also the atmosphere which is being created there in the courtroom. Our Honorable President is very, very witty. Many a times he cracks jokes and shares a number of anecdotes also. On the judicial side, recently, friends, you must have observed that Honorable Justice, Honorable President has come out with some of the formats, particularly in the case of Section 7 and Section 9 application, the orders which are required to be passed, admission orders. The format of the orders have been released, and it is expected from the bench that the councils shall submit, fulfill the comply with this format, and they'll give a draft order to the bench to facilitate the announcing orders at the earliest. Another is a format of the resolution plan approval order has also been released, and we, the lawyers, are expected to prepare a draft order and submit to the bench again, so that once an order is reserved, the order may be pronounced at the earliest. There are many remarkable changes. The way the Honorable President working along with the entire team is really, really commendable, and we really appreciate, and we really convey our gratitude to you, sir. Over to you, sir, for your address. Thank you.
Thank you, GP Madan. Yes, always my blessings is there to all the members of the bar. And I have always been on the forefront to encourage young juniors for one good reason, that the baton of law and justice cannot be held by one person in perpetuity. Therefore, there is a duty cast upon us to create the next generation of lawyers for the betterment of this country. And as you all know, the Constitution framers were majority from the legal fraternity. We have a great role in the growth and economy of this country, in the welfare of the people, and also to inculcate into the minds of the people the impact of Constitution and also the role of citizens, as we see enshrined in the Constitution. Good morning to all of you. Respected Shri GP Madan, Chair of the NCLT IBC Committee, Dr. UK Chaudhary, Senior Advocate, Mr. Pradeep Multani, President, PhD Chambers, Honorable Member Dr. Ashok Kumar Mishra, NCLAT, my dear brother member PhD Prasad, Abhishek Anand, Co-Chair of PhD Chambers, distinguished members of the PhD Chambers, and participants of today's program. I thank you very much for this opportunity. We have all gathered here to contemplate and give the valuable opinion in the form of panel discussions in relation to a key provisions of the Companies Act, namely Section 230, namely compromise, arrangement under liquidation, merger and acquisition, CIRP issues with respect to plan and implementation. At the outset, let me wish the participants the very best in the course of deliberations so that they come out with wonderful ideas. I always believe that when we have interactions of this nature, much light is thrown on the way we approach the problems that we face in the adjudicatory process, and also enables the legal fraternity to address the issues in a different perspective based on the outcome of such sessions and conferences. On the three issues that we have to deal with on today's program, Section 230 of the Companies Act deals with the power of compromise or to make arrangement with creditors and members. It includes mergers, demergers, and amalgamation of companies, or even corporate debt restructuring. When a corporate debtor under the code goes into liquidation, the adjudicating authority may direct the liquidator to consider provisions under the 230 of the Companies Act as a last attempt to keep the company as a going concern. This came about by virtue of NCLAT order in Sekaran versus Amit Gupta, where there was a direction to take steps to and form a scheme under Section 230 of the Companies Act. The NCLAT placed reliance on Swiss ribbons decision of the Honorable Supreme Court. The NCLAT also relied upon the case of SLR Metal versus Satish Kumar Gupta, primarily on the concept of revival and rehabilitation of an ailing entity. The NCLAT gave the first impetus by enabling the liquidator to proceed in accordance with 230 of the Companies Act. It appears there was an ambiguity as to who could propound such a scheme in the light of disqualification under Section 29 capital A, and that was further clarified by the NCLAT and also by the Supreme Court in Arun Kumar Jagatramka versus Jindal Steel. That is no more an issue. But in paragraph 95 of that decision, the Supreme Court stated as follows. This juncture, it is important to remember that the explicit recognition of the scheme under 230 into the liquidation process under IBC was through the judicial intervention of the NCLAT in Shivram Prasad versus Dhanapal 2019 SEC online. Since the efficacy of this arrangement is not challenged before us in this case, we cannot comment on this merit. However, we do take this opportunity to offer a note of caution for NCLT and NCLAT functioning as an adjudicating authority and appellate authority under the IBC respectively, from judicially interfering with the framework envisaged under IBC. As we have noted earlier in the judgment, that IBC was introduced in order to overhaul the insolvency and bankruptcy regime in India. As such, it is a carefully considered and well thought out piece of legislation which sought to shed away the practice of the past. The legislature had been working hard to ensure that the efficacy of this legislation remained robust by constantly amending it based on its experience. Consequently, the need for judicial intervention or innovation from NCLAT NCLT and NCLAT should be kept, it is bare minimum, and should not be disturbed the foundation principles of IBC. This conscious shift in their role has been noted in the report of the Bankruptcy Law Reforms Committee 2015 in the full stop. Therefore, the prohibition placed by Parliament in Section 29 capital A and 35 1F of IBC should also attach to the scheme of compromise or arrangement under 230 and 2013 Act. In this background, we have seen certain cases where after the liquidation order is passed, the scheme of arrangement has been propounded at the instance of the liquidator. But I find certain issues which needs to be considered in this deliberation. The structure of IBC 2016 exclude shareholders' participation in the resolution process. On the contrary, scheme of arrangement under Section 231 of the Companies Act, 230(1) of the Companies Act stipulates holding of meeting of creditors, namely secured, unsecured, trade, etc., and shareholders to be called separately, and an approval of the scheme by majority vote of 75% in each of them. However, secondly, the creditors or members of meeting under Section 230 cannot be reduced to a farce by only recognizing the votes of only those members who are able to make it to the meeting, because the law explicitly recognizes voting by proxies in such meeting. However, under Section 36 of the IBC 2016, a majority of 66% of the committee of creditors is required to vote. There is no present and voting method contemplated under the provisions of IBC 2016. How do you reconcile 70% vote with 66%? And what happens to the shareholders? This is for you to deliberate. There have been numerous instances in India and in UK where companies have been in liquidation for years altogether and have been ordered to be revived based on schemes of arrangement. Full stop. The core issue that requires consideration in this conference is also as to how the relief and concession can be granted under a 230 scheme. Because under the IBC regime, reliefs and concessions are sought for, whereas under Section 230 of the Companies Act, the company in question have to report compliances under the various provisions of law, namely statutory laws. Another issue which needs to be deliberated by this in this conference is, after approval of the plan, the successful resolution applicant many a times takes further time to implement this plan or the scheme. And they have been appearing before the tribunal seeking extension of time. This is causing a lot of concern with the NCLT because we find that the timelines are not being maintained. Once a liquidation order is passed, by virtue of the NCLAT order and the new amendment to 230 Clause B, the implementation of the plan comes into effect if there is a proposal by a person who is other than an ineligible person. if a plan is approved under the IBC, under the 230 regime, if it is not implemented in time, then we will have to see how the rigors as applicable under the regulations, IBC regulations, should be imported into such a plan. The deliberation should keep in mind the major failures in implementation of the resolution plan is because in many a case there is no robust means of source of funds provided by the resolution applicant, and they keep asking for extension of time. And I can quote instances, many even before my court. Therefore, it takes a lot of time for us to actually accept such a proposal, because ultimately the plan has to succeed and we have to ensure that the proponent of the plan is sound and is able to comply with the timeline which is specified. The other subject of discussion is merger and acquisition, of which I do not wish to comment much because the panel discussion would throw out some issues which is causing some difficulty on merger and acquisitions. But I can say one thing with a sense of satisfaction, because I was going through certain statistics of the NCLT from its inception. As of 31st August 2022, that is last month end, we have received in the NCLT 1,525 cases on mergers and acquisitions, and freshly filed cases is 13,340. The total cases that has come into NCLT from the High Court and also by fresh filing is 14,865. Number of cases disposed of by NCLT is 13,701. The pending cases as of today is 1,164. The percentage of disposal of cases is 92.1%. Therefore, in the field of merger and acquisitions, I think we have a cause to appreciate all the stakeholders, including the legal fraternity, because the results show the success of the manner in which we are conducting cases relating to merger and acquisitions. However, if in the course of discussion, certain issues are flagged that can be addressed. Incidentally, one of the charts that I have submitted with the approval of my other colleagues and members is also on ease of completing petitions filed under 232, so that the timeline is much reduced. We can achieve 100% result at the earliest point of time. At this juncture, I would like to thank both Mr. Madan and Dr. UK Chaudhary for expressing their concern as to why there is a little bit of delay in disposal of cases, though, according to me, as between the ratio of number of NCLT benches, members, and the cases, the output is far higher than expected, and it is remarkable. It is true that some big cases are taking larger time. It is only because, due to shortage of judicial and technical members, we are unable to give our full concentration on individual cases so as to resolve them at the earliest. I say so this with certain conviction. As I've seen in United Kingdom, in Australia, and also in American judicial proceedings, the size of the case, the magnitude of the case, or its financial implications may be big. The numbers may be a little smaller. But the time that a judicial member or a technical member takes to hear and dispose of the case, and his ability to give his full attention to a particular case is much, much higher and wider. Whereas in India, as I've seen from the High Court, from various courts, and also taking a cue from the record of the Supreme Court, we find that the judges in this country outperform in numbers because the cases that come to the courts are in huge numbers, and therefore we find it difficult to give quality time to each and every case. But nevertheless, we find that in majority of the cases, justice has been done. But there may be some delay, but that is inevitable due to factors other than in the system, except that there is the requisite numbers are not there. This has been rightly flagged by Dr. U.K. Chowdhury, and we hope and expect the government will address this issue at the earliest, and the members of the bar to also make their endeavor with the government, expressing the difficulties both in terms of the adjudicating authority as well as the appellate authority, as well as the difficulties faced by the legal fraternity. Please keep one thing in mind. IBC, as I find that IBC is a code that needs to be implemented within its framework and has been right and very appropriately highlighted by the Honorable Supreme Court in the case which I have just quoted. It is so because if we do not work within the framework of the code, then it will lead to a situation where there will be different views from different quarters, and that will lead to confusion and multiplication of litigation. It is always best to stick to the rule and the code so that there is uniformity and there is predictability of decisions of the tribunal. Because the end result is a litigant does not want a thesis or a theorem on a judicial adjudication. All he requires is a result for his case. And the IBC is a framework, it's a code. We can only suggest to the government to correct it wherever there is some difficulty, and that is achieved by conferences of this nature. And once we tweak the code, which we are doing so from time to time, it will be workable. And with the full strength of the members and the cooperation of the bar, which I already have in abundant measure, I can say with certainty that the best bar is now before us in all the cases, and their ability to focus and address issues is extraordinary and exemplary. With these words, I would like to express my inability to participate in person for simple reason. Is not that I could not have reached there. But as much as you are interested in a conference on a subject relating to 230 of the Companies Act, my time, which I have fixed today morning, is on the overall improvement of IBC, and the conference which I am having with my brother members is also on the same subject of not just the Companies Act, but on the overall implementation of IBC, Companies Act, and how to go forward for efficiency in the adjudicating process. And I had to join all members by 11:30, so that is why I requested to allow me to join through VC. I may be excused for that. I thank one and all for the opportunity given to me, and I hope this conference comes out with the resounding results and success. Thank you, one and all.
Thank you, Honorable Justice. Sir, we are really privileged to have you with us in this inaugural session. You have raised very pertinent issues and a number of challenges also, which we, the professionals and the benches, are also facing. Sir, you talked about the larger cases, and we are witness to that in some of the real estate cases. In one particular case, more than 100 applications have been filed, and the benches have to clear those applications before the turn of resolution plan comes. So thank you also very much for clarifying this myth about the disposal rate. As you said, the 92.12% of the merger applications have already been cleared by the adjudicating body. So we are all, I on behalf of myself, on behalf of all the dignitaries sitting on the dais, on behalf of the chamber, convey my sincere thanks to and gratitude to you, sir.
Thank you. My pleasure. Thank you.
Honorable member has to leave. I'll request meanwhile our president to kindly felicitate Mr. Prasad with a plant and a memento, please.
Sir, we'll come to you personally to convey our gratitude. And
I'm just waiting for Abhishek Anand to say vote of thanks, then I will leave.
No, sir, Abhishek, before Abhishek, sir, Honorable Technical Member has to give his address. Abhishek turn will come later on.
Acha, okay, sir. Mr. Ashok Kumar.
When Abhishek joins, we'll again give you a call, sir, so that you can.
No, I will be here for a few minutes. There's no issues. You put it in the file.
Thank you very much.
We'll go there. You have to order actually.
Now I invite Dr. Ashok Kumar Mishra, member Technical National Appellate Tribunal. Before joining NCLAT, Honorable member has been with the NCLT Bangalore bench. And
Oh, I see.
in Bangalore. Okay. Okay. In that particular bench, Bangalore bench, out of 34 judgments, Dr. Ashok Kumar Mishra ji has, to his credit, more than 1,600 judgments and orders. And not with respect to IBC, but number of judgments and orders under company law also, maybe with respect to M&A, restoration of companies under section 252, reduction of capital, operation mismanagement under 241, 242, and some of the earlier cases which came to them from CLB under section 397, 398. Honorable technical member is for your knowledge, is a chartered accountant also by qualification, and he has been recipient of Best CFO Award in Public Sector from Institute of Chartered Accountants of India. He's as the name suggests, he's a doctor, has done a PhD in finance, and along with many other meritorious activities, recently he wrote a book on a practical guide to insolvency and bankruptcy code 2016, were released in the month of March 2016 at the event which was organized by NCLT Bar Association. Yeah. And again, today morning, I came to know that he has finished one more book. And you'll be surprised to know the topic, nothing to do with law, that is on contract management in manufacturing sector. Over to you, sir. Thank you. Thank you for being here with us.
Put the shoes, you have to go there.
Good morning, namaskar, namaskara to all my sisters and brothers. Mr. Madan, President of the PhD CCI, Mr. Maltani, President CCI, and Mr. Madan, this chairman for NCLT and IBC Committee, PhD CCI, our Justice, Honorable Chief Justice Retired Ramalingam Sudhakar Sahab, President NCLT, Dr. UK Chaudhary, the most eminent senior advocate, not only in NCLT bar, but I think in NCLAT also he does the same. Then Mr. Abhishek Anand and Dr. Singh. Let me tell you, I was not aware that I have to deliver a talk. When I was traveling somewhere, Mr. Madan met me and then he mentioned to me, sir, will it be possible to address? I told a topic you can give me, just tell me any time on anything issue, I can speak something, whatever I know, little knowledge I have. Let me tell you, first thing I must tell that today morning when I was talking to Mr. Maltani, the President PhD CCI, he has mentioned certain problems. And I think I should start from problem, then I will tell you the law position also in 10-15 minutes. I will not take much time. He told that you see MSME, which is the backbone of the economy. If India wants to become 5 trillion economy, it is MSME is one of the backbone. Now you know they are supplying mostly, or they are one of the largest supplier by number to the PSUs. What is happening, PSUs on one ground or the other, they are delaying their payments. Now their operation cycle fails. Operation cycle means when you have raw material, you purchase raw material, then processing cost is there, means you pay workers and other thing, final output comes, then you sell the material, then you realize the money. If the realization of money gets blocked, naturally the industry or the organization will become sick, means operation cycle will fail. What he has told is a very valid point, and even although in the IBC there is no prohibition for public sector, they are at par being treated like any other private company or a listed company. But still what is being happening and what the people should be cautious. You see, law will help you through a procedure. But what we have to do is that we should be cautious. Whenever you get a letter, particularly on quality, quantity, or variation in purchase terms and condition, you have to respond very fastly and cautiously. As far as since I was in NCLT also and NCLAT also, there is no such a special affection, because we always tell either you sort out his payment or face the consequence. So naturally in 2-3 months they sort out the problems and issue gets resolved. Particularly wherever I was there in NCLT, that was mostly my trend. But in NCLAT I am an appellate authority, my jurisdiction is restricted to the relief claimed. So that relief becomes a bounding duty. But what he has suggested, let me add further to it. Even in the resolution plan, what I have seen, these operational creditors are the most sufferers. Their industries are getting, or organizations are getting closed, not because of one reason or the other, because in the CIRP, what we call corporate insolvency resolution process, there also committee of creditors takes up the ownership. And when they are approving, naturally they are more interested, and the act has provided also like that only, they get priority in payment. So it is the large financial creditor, they are getting back their money, whereas these operational creditors like MSME and others, they are not getting, they are even getting zero amount, which is a sad feature. And I think Mr. Maltani, the president himself, will have to take up with the government when the new budget is coming up, because through Finance Act also some of the amendments at least can be mentioned or pushed through. Now for the government company, as far as PSU is concerned, the Honorable Apex Court in certain judgment, because we were treating them also at the same par and footing. But it has been clarified. I think Mr. Anand can give citation number because they are all experts. So they have clarified that public sector government dues, central government, state government dues, if in any way it is secured, it will come in the same priority, whereas we were treating in a normal course. So this is one of the area which I will request only Mr. President can take up. Now another issue what has been raised by Mr. Chaudhary, the learned senior, there I call counsel here, learned senior advocate, he is the learned man. His presentation and articulation I have seen in the bench when I am sitting. Now what he has raised a very valid issue. It is the restructuring. I think President Sir is also here and hearing. The restructuring of NCLT and LAT is also required. But what has happened, we have not, whatever strength was fixed, 63 or whatever year 11, these strengths were fixed only when we were having only Company Act. Now in NCLAT also two more acts have been added up, IBC and competition law. The cases under competition law are not less than the cases under the company law. Now what will happen if you provide the same number, same thing, then the speed naturally will get affected, it will get channelized. So the question is that how it is to be taken up, because the rule think tank of the present government is Niti Aayog. I was just wondering whether I was just, while I was talking to you, I was just looking at the Google, that is the best thing. There is no member law in Niti Aayog. If there is no member law, who will push your case? Nobody is there to push your case. So this thing only Mr. Maltani, as being president PhD CCI or through his committee, he can only take up. So that the strength of these two organizations are also to be strengthened. Not only this, even the manpower sanction and all other things like steno, PAs, if the stenos are not there, even if I dictate one dictation, it will take its own time to come up with the current strength. So why, when we tell that the CLB system didn't work, we do not know what will happen even to the NCLT and NCLAT. In the government, there is no system, at least in the legal framework, for impact evaluation study, which we generally observe that is being done for most of the government schemes. But as far as these things are concerned, there is no impact evaluation study. At a certain point of time, we change the law. At that time, we give certain data, how much time, average time they are taking or not taking. So these two issues, what has been pointed out by our Honorable President of PhD CCI and Mr. Chaudhary, that issue. Another issue what was raised was on the mediation. Let me today tell you, even in one of the Honorable Apex Court judgment I have seen, it has been clarified, it is not the job of NCLAT or NCLT to get on mediating between the parties to get the matter settled. You have to look at the law, interpret the law, decide in accordance with law. Reference I will everything need on your co-chairman of the committee, Mr. Anand, to give the exact citation number. So what is happening with all these processes, that what we are expecting, unless the law, because like in US, mediation is the first stage. Here we just go and get it. Let me tell you what will happen tomorrow. Suppose if some impact evaluation is done after 3 years, 5 years, what will happen? We will come to know, instead of reviving industry, we have closed down our industry. Because simply to progress any industry, you need the backbone. If your backbone through a process of law is getting mitigated, what we are getting? We are getting nothing. Because we will come to the very bad situation. So for the industry, this is one aspect. Now, I have told about Mr. Chaudhary restructuring also. Mr. President was telling you some of the provisions and explaining through a case law. I have heard him also when my book was inaugurated. I am lucky to have President NCLT also, apart from my chairperson NCLAT also. What he spoke at that time, let me tell you, the bar and bench relationship is the most important thing. Here there is no material labor side. Here what is important? Bar and bench. If both have a good coordination, then only litigant can also get advantage. It is one thing that we feel if you appear more number of time in a particular case, your fees is increasing. No, your image will come down. If you get some litigant's problem solved in 1 or 2 hearing, you will have a better scope. Your name will be there. Your marketing, this is the marketing technique. We should not kill, being a proprietary vendor, we should not kill the other organization. So that is one thing, or the other side. That is one of the point what sir has told, that is also very important. Now, coming to the topic which Mr. Madan just mentioned, I thought I can, off the cup, I can share with you. As far as my knowledge on the literary part goes, this corporate structuring are of 2 types. Operational restructuring, financial restructuring, and then third type of, while I was sitting, then I was thinking other type of restructuring also there. Whenever a large family, when they get, naturally we have 3 brothers, today or tomorrow there will be separation. At that time also there is a restructuring, sharing of companies, sharing of industry, sharing of organizations, these things happen. That also requires a certain approval through this mechanism. Sometimes it is coming up because fight is, we are having a good quality of fighting also. So some way or the other it is also coming up. And I have found as far as these compromise, arrangement and amalgamation section 230, if my memory is correct, Mr. Anand can always correct me, to section 230 to 236 particularly deals with such cases of arrangements, compromise or amalgamations or demerger. All these things comes up. When family separation is there, it is a demerger. So these terminology, so different types of corporate restructuring is happening. Now what is operational restructuring? Just for the term I am telling you. Operational restructuring means if your company is not making viable profit, or if the economic trade cycle suggests that a certain business is going to be very down, there is no market after 3 years, 2 years, 5 years. At that time you think of differently. At that time you decide which part I have to strengthen, where we have to retrain the workers, where we have to get them a technology, where we should go from the existing business to that side. These types of things, whenever you think in an organization, or some part you will get it closed. So that is called operational restructuring. But as far as financial restructuring is concerned, then all these terminologies are there, because either in the format of arrangements, compromise, demerger, merger, amalgamation it comes. And sometimes to take advantage of the lacuna in law, or you can say taxation provisions under the Act, then also we go on moderating these issues, considering the interest of the organization. Take the example of Google, how they have started, all subsidiary of Google, which was in Google, they have removed and put it in Alphabet. They have all become a part of that. Now even, I was just wondering when he told me theoretically that I may have to tell you about the concept. Then I was looking after even Facebook, WhatsApp, all these things have become, all these things, Facebook, WhatsApp, these organizations have gone for a Meta. That will be a holding company. And business verticals, different business verticals will have different company. Sometimes these are coming under financial restructuring, including sometimes you will find some industry name is very much coming up in our country. And he is becoming one of the I think topmost assets worth man. At that time, what you have to see, whether he is getting from the debt leverages that type. Suppose in a company that there is a limit for a debt. If you go on multiplying the debt today or tomorrow with slightly change in the structure, you will fail. You will not fail. Bank will fail, which has given you lakhs of crores of rupees. So that is more important. But so all these concepts are under corporate restructuring. Now every law, whether the company law, whether the IBC, Insolvency and Bankruptcy Code, or even I am adding third law, competition law, all these three laws, you will find one thing very common. No civil court has a jurisdiction, or they bar the jurisdiction of civil court, and only the respective tribunal, NCLT, has jurisdiction on IBC and company law matters, and CCI about the competition law. This act is very good, nicely drafted, everything is okay. What happens in interpretation when it goes, then it takes a different format. Like even in IBC, one provision, if my memory is correct, or Mr. Madan can also correct me, in section 31, if they are forming a combination, they are supposed to take the approval under the Competition Act. Somebody is telling it is directory, somebody will tell you mandatory, but there is a provision, whether directory or mandatory, it has to. CCI says mandatory. See, I am telling you both the sides. So in this context, you are to, these are the acts, interlinked acts. As far as the students are concerned, for them all these three acts are interconnected, because these are the corporate laws. And in the corporate laws, basically, if you think peacefully, these are all coming under financial restructuring. Financial restructuring, if you go further issue of capital, when your debt leverage goes up in the company, at them you think of to cover up the risk, why not to have some capital in the company, so that the balancing of the debt to equity capital, which normally in my olden time when I was studying was normally being told 2:1 is good. Now if you go 9:1, then only the God can say, which some of the industry in India is doing today. And we all invest in mutual fund. Mutual fund is also full of risk. Like today the banks are failing, you never know what will happen to mutual fund. Let all of us be very clear about that. So these financial restructuring, there are multiple provisions, not only section 230 to 236. There are provisions where reduction of capital is also required, where over gearing to the equity side is there. You want to reduce the capital, you don't need money because you cannot invest in other industry. At that time, that is also becoming a part of financial restructuring. So many issues. Then if you have taken a deposit, you have to pay back. That is also a kind of a restructuring if your business is not supporting. So this concept is a very larger concept, and I hope I have just gone through, all are eminent professionals. Let me tell you, in NCLAT, even as technical member, what I see, counsel for appellant, counsel for respondent. Here both the side decides, very easy, not a difficult job. But when you have to decide here and you have to get into a concept, then you will have to apply the mind, which is a necessary infrastructure. Now I can, as far as when I sit or when my colleague sits in the bench, we always keep in mind litigants, no doubt. Because what happens if you keep the same case 4 days by just deferring from 1 day adjournment, it may be of some help, but it gives a bad image to the other side also. So when we are dealing, we are also keeping in mind litigant, and that's why certain pressures were built but we are also under the umbrella of the statutory act. We are all NCLT and NCLAT has to operate within the boundary of the act. We cannot go, we don't have a constitutional power which Justice Sudhakar was having when he was a High Court judge. Because here we have to work within the framework of the statutory act, and although principle of natural justice is applicable, so we are keeping these factors in mind, and my request to bar is also there that bar and bench, whether for NCLT or NCLAT, may have some type of interaction even half yearly, so that a clarity of several concepts, operational difficulty also comes to light. And I am happy to tell you, although the President, Honorable President spoke from the BC, but one thing is clear, this hybrid hearing, I think, is the future of India, and let all of us to prepare for that. With this, let me thank Mr. Madan, Mr. Chaudhary, Mr. Anand, Mr. Multani Sahab, I have known today only. So I am thankful to all of you, and Mr. Singh, Dr. Singh also, for calling me here, and all of you have heard something. So I am thankful and grateful to all of you. Jai Hind.
Thank you, sir. Thank you, Honorable Member Technical, Dr. Ashok Kumar Mishra. Sir, without giving the citation of, sir, without naming rainbow papers, you have already said that rules of the game are being changed now, and there are efforts to rewrite the law. But I'm sure I came to know that a review petition is being filed in that case also. Let's see what will happen. But in Vidarbha case, the review petition has already been dismissed. Rainbow paper, the review petition is being filed. So you talked about role of mediation of NCLT and IBC cases. I think that role is already being played by NCLT benches, because whenever a creditor or a corporate debtor, they approach the court that we are in the process of settlement, so the time is being granted to them so that a mediation may happen between the parties. And I'm really thankful to you that when I met you at Calcutta airport, you immediately said yes to me that we will come. Thank you so much for being with us. Now over to my younger brother, Mr. Abhishek Anand, for his vote of thanks.
Good afternoon, everyone. I first thank Honorable President Justice Ramalingam Sudhakarji, Honorable Guest of Honor Dr. Ashok Kumar Mishra, Member Technical NCLAT, our PhD Chambers President Mr. Pradeep Multani, my chair Mr. GP Madan, NCLT and IBC Committee, and Dr. Jatinder Singh. So we have heard everyone, and in fact, as a vote of thanks, I would say that the key points today we take into the seminar is 4 challenges, which I think we face not as a bar, but even the bench is facing, which is, I would say, the infrastructure. The government probably will have to look into the fact that yes, 63 members were required for this tribunal to function and to become one of the best tribunal in the country, because we have jurisdiction from High Court, we have jurisdiction from BIFR, and even the AFR which came to NCLAT. Now, today, the IBC was not required to be made an adversarial proceedings. But when we look at the cause list every day, and Mr. Madan also mentioned one of the cases that there are 100 applications pending. And when we are aware that the benches are functioning, taking 3 benches in one day, I don't think that those 100 applications can be considered in a single day. And we can't expect as a stakeholder that all matters will be decided in a manner with the speed which is required to be done. When we say time was of the essence for IBC, and I think the government will have to look, the time was also of the essence to appoint members so that the infrastructure was there with the tribunal to function in a manner which was required, which is ultimately the speed in which the matters were required to be dealt with. Now, Honorable Justice Ramalingam Sudhakarji has pointed out certain issues which in fact will guide us into the today's seminar with respect to section 230, that whether reliefs and concessions can be granted under a scheme under 230, whether a shareholder under 230 subsection 1, whether eligible under 29A or not, can submit a scheme for compromise and arrangement. Then other issues which were raised with respect to the issue of time, that the matters are pending before NCLT, before the appellate tribunal. But we all have to look into the fact that the tribunal and the members therein are working from 10:30 till 7 p.m. On daily basis. And us as lawyers, in fact, have made this IBC adversarial. As lawyers, we take our own time and argue a matter which could be finished in 15 minutes, we can take the entire day. So we can't, in fact, blame any delay on part of the tribunal. In fact, the delay is on part of the government, which should look into the fact that if you want IBC to strive through, that the other countries which have this statute already with them, which have already taken into account the issues and challenges which the government should look at this stage. In fact, when we look at the NCLT and NCLAT disposal rate as mentioned by Honorable President today, that in merger and acquisition 92.5% disposal is there. I would say that same rate would have been there for IBC matters as well, if in the event the tribunal had the entire strength with all member judicials and all member technical. The speed of, if we compare the speed of disposal from 2016 onwards to 2020, when the COVID hit, prior to COVID, when the strength was for 45, even that strength was not up to the mark, because 63 was required for the purposes of only the company law jurisdiction. Now, 3 jurisdictions, SICA, company law, IBC, everything merged into the NCLT, and therefore, ultimately, until and unless that infrastructure is built by the government, where the honorable members, judicial, technical, have that assistance which is required, which includes even the stenos, I would say. Until and unless that is given, the IBC cannot strive. Neither the Companies Act, because the benches are, in fact, after Honorable President has come, we have a single day of Companies Act, which is Thursdays when companies matters are listed. Even that day, we have tried, in fact, get our insolvency matters listed on Thursday, because we know on Thursday it is a company matter, but we somehow get our matters of insolvency get into that Thursday day. So I think that bifurcation of Companies Act and insolvency matters can be done if the tribunal has enough members, so that a separate bench can be constituted only for the merger and acquisition matters. And if that is done, I think the speed which we are looking, which the stakeholders are looking, will definitely come into picture. With that, I thank everyone today, the dignitaries and the participants, and I ask Mr. Singh to continue.
Thank you, Mr. Abhishek Anandji. In fact, you have given a gist of the entire inaugural session. Thank you very much. And I'll request our president, along with chair and coaches, to kindly felicitate our domain experts and our honorable guests from NCLAT, and also Dr. J.K. Chaudhary. Sir, if you can kindly felicitate them. Thank you very much, sir. Thank you indeed. And ladies and gentlemen, so we are through with the inaugural session. We have another session, the first technical session of merger and acquisition. We can have a 1 minute or maybe 2 minutes bio break, and then meanwhile we will just arrange the tables. Thank you very much.
The tea break will be after first technical session. Please join within 2 to 3 minutes. We'll start the session.
Same judgment came in SRC, turned down by Supreme Court. It came from NCLAT only. It came from NCLAT last time, that some money should go to the operation. Absolutely. Everything should not be appropriated. We can tell you the figures. Every time a big company goes down, like changes hands, like Ocean Steel, Ocean Power, SR Steel, and there are so many of them, more than 1,000 SMEs go down. They become insolvent. अगर उसका 20 करोड़ रुपया नहीं मिलेगा, 1 रुपया मिलेगा उसकी जगह, तो how it will
Haircut इतना हो रहा है 90% that is
वो हमने इसीलिए रिवर्स किया था, बैंक ले जा रहा है। वो काफी लोग वो चाहिए, वो करना है। And as the president says, it's the backbone of the whole. $5 trillion हो या $10 trillion, the bigger companies cannot continue. It's the smaller MSMEs जो लेके जाएगा। Sir, it's already there. It's already there. The signs are already there. It is good. It's becoming from bad to worse.
मैं इधर ही मैं इधर आ जाऊंगा ना, मेरे लगा हुआ है। मैम को इधर प्रधान सर की चेयर चलेंगे। Good afternoon, everyone. So today we start with our first session, which is with respect to merger and acquisitions. And we have three eminent speakers with us who are in fact practicing in NCLT and all, in fact, high courts and honorable Supreme Courts. So I will first welcome Ms. Pooja Mahajan, Managing Partner, Chandiok and Mahajan, to give her view on the issues pertaining to merger and acquisitions and the technical issues which as a challenge they face in and out before the courts and with their corporate clients. Over to Pooja.
I think I'll just go there and stand there. A very good afternoon to everyone. I'm very conscious of the fact that we are running a little late, so I will try to wrap up my thoughts as soon as possible, perhaps in next 10-15 minutes. Now, the topic that we have for this panel is mergers and acquisitions. And as you all know, the mergers and acquisitions have been around since innumerable time. And the reason is that it's actually a way for inorganic growth for companies. Since time immemorial, we've been seeing companies coming together, business houses coming together, merging, demerging, amalgamating, acquiring each other. And the basic reason for that is the synergy. The essential principle of a merger and acquisition is that 2 + 2 = 5. The two entities, when they come together, be it by way of a merger or an amalgamation or an acquisition, together are much stronger even than their individual parts. And that's really the basic reason why we see so much M&A activity going on. There are 4 basic ways in which a merger and acquisition can be undertaken. The 2 are private and the two are through NCLT route. The most common way of doing a merger and acquisition is the share acquisition, where one company would acquire the shares of another company, and that I would say is perhaps the largest, and in terms of volume, most of the M&As in India are taking place through the share acquisition. We also have mergers and acquisition which take place by way of business or asset transfers. So you could have, for instance, a business transfer from one entity to the other entity under a business transfer agreement. You could have itemized sale, and that also does not really require an NCLT approval. These are contractual arrangements which are negotiated between the buyer and the seller, and they can be achieved fairly quickly. Perhaps even within a few days, you can have one business entity being acquired by the other business entity, or you could have one business being taken over by another entity. The two other ways of doing mergers and acquisitions are through NCLT mechanism. The first is by way of a scheme of arrangement under section 230 to 232 of the Companies Act. And the last one is mergers and acquisitions under the Insolvency and Bankruptcy Code. Now these two, as far as Companies Act is concerned, the mergers and amalgamations under Companies Act, of course, have been happening under the 1956 Companies Act as well. And again, the jurisprudence as far as Companies Act, mergers and amalgamations is concerned is now very well settled. It moves on the principle of, just like IBC, it moves on the principle of commercial wisdom. In fact, the principle of commercial wisdom that has been now part of the IBC after the Shashidhar judgment is actually a principle which has been taken from a scheme perspective, from when the schemes were being approved by different courts, earlier high courts and later CLBs and NCLTs. The principle was always commercial wisdom of the shareholders and the creditors will reign supreme. And that was then subsequently imported into the IBC mechanism as well. Now, coming first to the merger and amalgamation process under Section 230 and 232 of the Companies Act, the reason why you would choose to do a merger and amalgamation under an NCLT scheme as opposed to a private arrangement is that the NCLT mechanism of a scheme gives you a single window clearance. In case one company has to merge or amalgamate into another company, the only way to do it is actually by way of a scheme of arrangement. As privately, you cannot have a situation where one company merges into the other and loses its identity. That is not possible. So that's the first reason why you would want to have a merger and amalgamation through the NCLT process, because it gives you a flexibility and a capability to actually merge one company into another, where one company can lose its identity. The other thing you could do under a merger and amalgamation, though it's not very common now, is you could even have a debt restructuring under a scheme of merger and amalgamation. So you could tie up a classic merger and amalgamation where one company gets acquired by the other company, along with, let's say, a debt reduction or a corporate restructuring, which is also possible under Section 230 to 232 of the Companies Act. And again, Section 230 to 232 of the Companies Act requires consents of the shareholder, majority in number holding 3/4 in value, of different classes, as well as creditor, different classes of creditors. And that is, I think, one key difference between what is there in the Companies Act and what is there in the IBC. The threshold for approval are very different. There is no concept of a cross-class cram down. You need to have different classes of shareholders. So you will need to have a class of, let's say, an equity shareholders and preferential shareholders. You need to have different classes of creditors, unsecured creditors, secured creditors, and the decision made by one class cannot really bind another class. You have concept of a scheme being binding on the class that votes on it. And that, again, like I said, is one of the key difference why debt restructuring under the scheme is perhaps more complicated, or can get a little bit more complicated, as opposed to a debt restructuring under the IBC, where you have only one class, committee of creditors, financial creditors, who can vote on a resolution plan. Like I said earlier, mergers and amalgamation under Companies Act, the scheme 230, 232, are not being used very effectively or very proactively for debt restructuring. It is used for mergers and amalgamations, and a lot of time these mergers and amalgamation happens between group companies. It's a very effective way for group companies to actually, let's say, consolidate their various group companies, or even for group companies to hive off different entities into different verticals. That again is very common and is being done fairly regularly as far as Companies Act is concerned. We heard eminent judges earlier talk about the fact that under the scheme of mergers and amalgamation, that is one area where NCLTs in fact have been passing a lot of orders. Unfortunately, with the coming of the IBC, and that again is an issue which has been highlighted by Abhishek as well, with the coming of the IBCs, it's just that the burden on the benches is so high that sometimes the merger amalgamation cases, which ideally should not be taking a lot of time, do end up taking a lot of time because the matters don't reach. So perhaps having a different bench or having designated dates for hearing these company law matters is something which should be, we should encourage that. The other way to really expedite this is to have draft orders ready. And for instance, in NCLT Mumbai, it is fairly common to have draft orders of schemes being presented to the benches. And the benches would take not that much time actually reviewing those draft orders and coming out with the sanctioned scheme. That's something perhaps that we need to implement across different NCLTs, including in NCLT Delhi. Because as far as the scheme itself is concerned, once you have the requisite majorities, be it of shareholders and creditors, the issues, given the fact that there is no debt restructuring which is taking place, the issues are not so complicated. Once the shareholders have decided that two companies will merge or amalgamate, and there is no disturbance as far as liabilities is concerned, it's a fairly straightforward process. Persons who have more than 10% shareholding or more than 10% debt, only they can object to the scheme. So in terms of objections itself, you will not find that many objections to the scheme as you would find, let's say, in case of a resolution plan, where even a single employee can come and actually object to the resolution plan. You don't see that happening in a scheme of amalgamation and merger. So that again is given the fact that you don't have that many objections, the real objections, if at all, come from either tax authorities or ROC or an RD or official liquidator, and they need to respond in a time-bound manner. So you have a provision which says that in case they do not file their objections within a period of 1 month, it will be deemed that they have no objections. That also helps in expediting the process, and perhaps that's something we could borrow and take even into NCLT and IBC process, where we can fix a timeline to say that if anyone wants to object, this is the period of time within which they have to object, and in case they don't object within that specified period, then it will be deemed that that objection, they don't have any objection. The last mechanism of undertaking mergers and acquisitions is for distressed assets, which we are seeing under the scheme of the IBC. Now, generally speaking, a resolution process is not an M&A process. And in most jurisdictions, it does not work as an M&A process. For instance, if you see Chapter 11 of the Bankruptcy Code of the US, it's effectively the company that gives a revival proposal, and that revival proposal is considered by the creditors and approved by the bankruptcy tribunal. But in India, because of 29A, given the fact that the promoters themselves, in most cases, apart from MSMEs of course, in most cases, they cannot present the resolution plan, the IBC resolution process ends up working as a merger and acquisition process, where you will have third parties who are not 29A disqualified. The third parties will actually be making a proposal for acquisition. So what I would say is that the IBC process has become, over the years, essentially due to Section 29A, a process of M&A, as opposed to, of course, process of M&A along with the debt resolution itself, but it's not classic resolution or revival of a company the way you were seeing it earlier, let's say under the PIFA process, or the way you see in a lot of other jurisdictions as well. Now, coming to the role of NCLT and NCLAT in an IBC resolution process, we all know that the parameters of judicial discretion as far as approval of the resolution plan is concerned. We all understand the concept of commercial wisdom. The scrutiny of a resolution plan, I feel, is a little bit more than a scrutiny you will find of an M&A under a scheme. And the reason is obvious. The reason is that in a resolution plan, you have haircuts. You have various authorities, operational creditors, financial creditors, actually taking haircuts. You have a cross-class cram-down where financial creditors can decide how much money is to be paid to operational creditors. You have a percentage of 66%, which is just by debt number, not by actual number of creditors. There is no distinction between secured and unsecured creditors when it comes to constituting a class for voting. And for all of these purposes, we have the concept under section 30 subsection 2 of minimum protections. The reason for giving minimum protections is because it's a debt resolution process. The section 53 waterfall needs to be respected, both for operational creditors who don't form part of the COC, as well as for dissenting financial creditors who don't vote positively in the COC. You have the minimum protection which needs to be given to them. And that is again another big distinction between the IBC and a debt restructuring process, let's say under a scheme of section 230 to 232. The other, of course, critical part that the NCLTs have to look at is compliance of law, and that was also something which was earlier, mentioned by Shri P.S. Prasad as well, that one of the things that the NCLTs have to definitely look at is compliance of law. And that is where things become very tricky, because we do not have, as of now, enough clarity on what all laws are we really talking about when we talk about section 30 subsection 2E. There is an overriding effect, of course, of the code, but that does not mean that that the resolution plan can override every other law. For instance, let's say there is a resolution of a defense company. You require under the FDI guidelines of the government, for a foreign investment in a defense company, you need various things. You need government approval, you need security clearances. Let's take another example, aviation industry. We had a case of Jet Airways, where the resolution plan for Jet Airways was approved, and you had approvals of the DGC and MOCA. Those are necessarily required. You can't get away with that and say, because the IBC has an overriding effect, I don't need to really take approval of the regulator. So you need to still respect law, and one of the critical roles of the NCLT is in fact to see that the resolution plan does not actually end up breaching any other law which is necessary for purposes of compliance. So these are essential differences between the two. Other difference which I would like to point out between a regular M&A process and a process of M&A under the code is, as highlighted in the EBIG's judgment by the Honorable Supreme Court, that in a regular M&A process, because it's a bilateral contract between a seller and the buyer, you end up getting a lot of representation warranties. There's an apportionment of risk. You get indemnities, you can decide which entity will take liability for a debt. Because you cannot wipe out the debt, the parties, the buyer and the seller, decide amongst themselves who will take responsibility in case something goes wrong. As opposed to that, and that's the reason why in a regular M&A process, you will find clauses like material adverse change, you will find clauses like force majeure, you will find representation, warranties, indemnities, caps, etc., etc. You don't find all of that in a resolution plan. A resolution plan is an M&A process which is driven by the code itself, and as upheld by the Supreme Court, it cannot be conditional. It cannot be conditional because there are immense benefits of doing an M&A under the code as opposed to doing a private M&A. For instance, like I said, you can wipe down the liabilities and you can start on a clean slate basis, which is not possible in a private M&A. And because of all of these reasons, the general principles of contract, which would otherwise apply in a private M&A process, does not apply as far as IBC M&A process is concerned. So again, it's a very attractive opportunity for anyone who's looking to pick up assets, for anyone that is looking for inorganic growth. A resolution process, an IBC resolution process, in fact, offers a lot of incentives. I think we've all discussed enough as to what are the issues that are there in an IBC process right now is the lack of certainty. While we had certainty when the judgment came, of course, in SR, after that Ghanshyam Mishra, there was a certainty that the resolution applicant had as to what will happen once he takes over the company. That certainty to a certain extent, I feel, has been done away with. Two basic reasons. There are, of course, conflicting judgments of various courts on what exactly can be extinguished, whether tax dues can be extinguished or not. And second is the time period. Any investor, especially foreign investors who are looking at a resolution process under the code, they look for time certainty. And there are a lot of judicial delays. And of course, the reason has been highlighted, we do not have enough members. And that has really resulted in a lot of uncertainty for the investors. One suggestion, of course, I mean, it goes without saying that really the most effective remedy to address a lot of these ills is to have more members so that the time at least can be saved. The other is perhaps we can come up with some sort of formats for approval of the resolution plan. Some of it has already been circulated. And also for objections. Perhaps there's time for court to fix who all can object to a resolution plan and what are the exact grounds on which a resolution plan can be opposed. For instance, in a lot of cases, you end up seeing promoters just objecting to the resolution plan for the sake of objecting. So some of those really need to be discouraged. And I think we are, of course, in the process of a lot of, hopefully there will be amendments coming up in the IBC. And as the process becomes more and more smoother, I think the IBC M&A will perhaps overtake a lot of other courses of M&A that we have. With that, I'd like to hand it back to Abhishek. Thank you.
Thank you, Pooja, for giving us an entire overview on M&A. And in fact, all the issues pertaining to the scheme, the private arrangement, and the solutions also which are coming forth with respect to draft orders. With that, I now call Ms. Shweta Bharti, Senior Partner at Hammurabi and Solomon Partners, to give us her insight into the M&A challenges and issues. Thank you.
Sorry, just before, yeah.
And today it's her birthday, so we wish her a very happy birthday.
And it's really her commitment to the NCLT and to the bar and the bench that we see her here on her birthday.
Thank you so much for having me. Good afternoon, everyone. It was the persistence of Mr. Madan who has actually brought me here. Trust me. So no, thank you so much, Pooja. You have given a very interesting oversight into the entire process of merger, amalgamation, and how it was being done and how it is being done now under the IBC regime, and the interesting mix that you spoke about with respect to the issues relating to resolution plan vis-a-vis the scheme of arrangement. Now, I would want to take a step back because I always like to start with history. So, Section 391 to 394 under the 1956 Act had its own advantages, disadvantages. There was a certain process which was provided for, where you have to first get the approval of the shareholders and creditors. Now, in the IBC regime, we talk about operational creditor, financial creditor. Under the Section 230 scheme, we still talk about, the secured creditor, unsecured creditor. So that difference is very, very clear so far as the operational creditor and financial creditor is concerned vis-a-vis the secure and unsecured creditor is concerned. So we'll get the approval under the first motion and then, approach the High Court. At that point of time, the company court used to take over those matters under Section 391 to 394. And then we'll file our second motion where we will get the approval from RD and OL, and then we get the approval from the High Court, the sanction to the scheme. Now, this process largely remains the same. There is not much which has changed so far as the process is concerned, because even now the process that we follow is after we get the approval from the board of directors with respect to the proposed scheme, what we do is get the approval of the shareholders and creditors if it is possible, and if we are able to get 90% plus approval of the creditors, we are able to get an exemption so far as the scheme of amalgamation is concerned from holding the meeting of those creditors. So far as shareholders are concerned, even if you have 100% consent, sometimes there are some benches who still have those reservations with respect to giving us the exemption for the holding a meeting of the shareholders. Having said that, the process thereafter has remained the same, except for the inclusion of the IT department, which has now come along with the RD and OL approval and the sector specific approvals that we need to take. And in cases of a merger of a certain threshold and above, we also need to take the consent of the CCI. But now what has happened, and this is one challenge that I have been facing, is the IT department consent that we have to take. IT department has been using this as an arm twisting method to get old claims also being settled, and unless and until we don't settle those claims, irrespective of whether I have a merit in my challenge or not. There is a concern that has been raised, and in fact, by a lot of lawyers in this regard, that IT department has been arm twisting to give the approvals. So if we could have a mechanism in place where we have a time-bound kind of a process, which is provided for, so far as the law is concerned, I don't see there to be a gap. But so far as the implementation is concerned, if we are able to have that kind of a process in place, I think that would really help in enabling and smoothening the process of mergers and amalgamations at the second motion stage. Also, I think if we can have a uniform kind of a process for, if we have the consent of the shareholders, in case of especially the, wholly owned subsidiary getting merged with the parent company, why do we need to have the consent of the shareholders and 100% consent of the shareholders? It is something where we, in fact, in many cases, the transferee company does not even need to file the application for consent, for the approval of the scheme of amalgamation. Only the transferor company files, and once the process of the approval is given, the transfer company gets merged into the transferee company. So I think those are processes which have really, streamlined a lot of systems in place. And I think that is a good progress that we have made. So I think one suggestion that I would give to PhD CCI is to also talk about a time-bound manner in which the NCLT should insist that the IT approval is there, or there is a deemed consent if, within a certain period of time, the consents are not given. I think that is something we should go even for the RD and OL approval, because a lot of cases where we have seen that RD and OL also takes its own time. And there is a lot of difference in terms of the working between the RD in the northern side vis-a-vis the RD and OL working on the southern side. So I think these are issues which we definitely need to take care of. Now, when I was talking about the historic part of the concerns which we used to have in the earlier times, the earlier time challenges were primarily in relation to the shareholders objecting. In fact, in one of the schemes that we were handling it in during the early times, the shareholder was able to actually stall the entire process of this approval of the scheme of amalgamation. One shareholder was able to stall the process for almost about 1.5 years. So that is something which is now, in the section 230, 232 scheme, that is something which has now been done away with over a period of time. I think that is a huge evolution which has happened. The second thing I think was the major landmark judgment of Mehraj Mafatlal, which has given clarity with respect to a lot of issues. Lot of issues with respect to the commercial wisdom of the shareholders, which Pooja also spoke about. Also in relation to various other issues, like the court should not be sitting as an appellate authority to, in fact, decide on the commercial wisdom of the shareholders and the creditors. So that was one very important aspect, in fact, that was taken into consideration in Mehraj Mafatlal. And then the concept of single window clearance, which again Pooja had mentioned about. Single window clearance is also one concept by which I think Mehraj Mafatlal had laid the way for it, and thereafter it has been followed since then. But now, over a period of time, what I'm seeing is that when the matters are now going before the NCLT and NCLAT, there are interesting kind of challenges which have started to come. In one of the cases that I noticed, where in the case of WikiKids, ultimately there was a notification which had come thereafter to resolve this issue. So in this WikiKids case, the NCLAT had observed that the scheme of amalgamation was designed to benefit only the promoters at the cost of the shareholders, as share exchange ratio mentioned in the valuation report was incorrectly determined. Now, once you have the approval of the shareholders and creditors, you also have the approval of the RD and OL with respect to a proposed scheme of amalgamation. Does it fall upon the NCLT or NCLAT to take a decision in this regard, and does it not actually fall contrary to what has been provided for in the Mehraj Mafatlal case? So ultimately, the government had to come up with a notification to clarify this issue. And this issue did not stop. Thereafter, there was another judgment where, the RHI India Private Limited versus Union of India, where because of the WikiKids judgment already being in place and the notification having been in place, the NCLAT then took into consideration the peculiar circumstances. Now here there was a unique situation where the NCLT insisted that your appointed date was different from the date of the valuation of the share exchange. So on that basis, the NCLT had dismissed the scheme of arrangement even after the shareholders and the creditors, the RD and OL, all of them had given their approval. So when it came to NCLAT, at that point of time, the NCLAT decided that this is not correct and that it is not upon the NCLT to decide on the merits of the scheme on the basis of the fixation of the appointed date in any which ways. I mean, in your scheme of amalgamations also, you make a provision that in case there will be, the appointed would be so and so date or any other date that will be fixed by the NCLT or NCLAT. So I think that when there is already an option available, if you have to change the appointed date, why not change it to a date of a certain this thing? Even if the NCLT is of the view that it should be of the date when the share exchange issue was, the evaluation was done, then that should be the appointed date mentioned. Why reject the scheme only on this basis? So that was one finding that was there in the RHI judgment. So what I have noticed is over a period of time, I think, because of different benches deciding in different manners, the NCLT at Delhi vis-a-vis NCLT at Mumbai or NCLT at Bangalore, Chennai, they have different views with respect to different issues. I think there needs to be a consistency in terms of the issues. And we also need to understand and probably make NCLT understand that from here at Mafatlal onwards, this issue has already been settled. And now you cannot play the role of, the adjudicatory, there is no role of an adjudicatory mechanism here. What you need to do is look as an empire if everything is being done in a proper manner. So I think that is something which needs to be brought into the system in a right manner, and a consistency of approach of all the tribunals across the benches is something which is very, very important and necessary. So as Pooja had mentioned, that lack of certainty is something, and which is where the whole gap is. So if we are able to bring in the certainty with respect to the procedure, I think that will help a long way in going into the ease of mergers and amalgamations. Second was with respect to the formats that you spoke about. The formats also, in fact, in the earlier times, also before the company court, we used to give a drawn-up order before the court. And that drawn-up order used to be the basis on which the court would pass the judgment. So it would not take much time for the court to then go into the merits of the matter, read each of the documents, because the drawn-up order is already available. That process is something which can be brought in even now, where you don't need to, because, as an empire, when you've seen that the entire process has been completed in a certain manner, then you don't need to adjudicate on any issue. It is about a procedural issue. So then thereafter, once you have a drawn-up order, you can make the changes according to the thought process of the benches. But then that is something which will ease the whole process a lot more. And so far as the objection to the scheme is concerned, I think that is still smoothened to a great extent. Now I think so far as resolution plan is concerned, there may be challenges. But so far as the scheme of amalgamations and arrangements are concerned, I think those issues have largely been smoothened over a period of time. We used to have those challenges by shareholders, as I mentioned, that one of the shareholders was able to actually stall the entire process of scheme of amalgamation for almost about 1.5 years. But now I think the courts have also become sensitive towards it, and the certain number of shareholders are required. Even if there is an objection to be raised, it has to be a certain number and above as a threshold. The third aspect was with respect to stamp duty issues that I wanted to touch upon, because I think this is also an interesting journey that stamp duty has seen over a period of time on the implication of stamp duty. If we look at the Hindustan Lever judgment, that was around 2003-2004 by the Supreme Court, where what would be the implication of stamp duty, and what is the rate at which the stamp duty will be charged, because it was at Maharashtra that the concern was, and there was no entry in the Indian Stamp Act with respect to mergers and amalgamation. So should it be charged in conveyance or not, and what is the rate that will be applicable, is where the Supreme Court had held that so far as that state is concerned, it will be charged as conveyance. But then the issue still remained, because a lot of states had not made those amendments in their Indian Stamp Act, and therefore the conveyance was not necessarily to be the rate at which the mergers and amalgamations were to be stamped. So this issue also, in fact, thereafter people started looking for states where the amendment has not been made, and then they will transfer their registered office to those states where, the implication will be less. So those kind of innovative mechanisms were being thought of, and then the Honorable Delhi High Court in the judgment of NCT of Delhi, I think they had, Justice Geeta Mittal had settled that issue so far as Delhi is concerned, that it will be on conveyance and that rate will be applicable. So I think that stamp duty also has seen a very interesting journey. Now almost all the states have already brought in that amendment, and therefore it is now to be charged at the state where the immovable property of the transfer company is located. So that has eased in terms of the processes a lot of things. So that was my thoughts. Any question I would be very happy to take on. Thank you so much for being such a patient listener.
Thank you, Ms. Panti, for giving us the insights. And in fact, we have noted the suggestions, which in fact are very welcoming, that all delays we see in the court is with respect to income tax, RD and OL's office, because they take their own sweet time, probably 2 years to even file a report. And even if they say the report is filed, which is never on record. So in fact, that suggestion that all benches should look into a time-bound manner by giving them opportunity, and if that opportunity is not availed, then that deemed consent should be taken into account. And also the second point, which is very important, is that consistency of the orders and the practice to be followed by all NCLT benches, I think, is one of the key take today, that all benches should look into that timelines with respect to passing an order under first motion and second motion, and therefore that consistency is much required. With that, I now call Ms. Ranjana Roy Gawai, founder and managing partner, RRG and Associate, to give her view on the issues and challenges pertaining to M&A, both as with the clients as well as with the courts. Thank you.
Thank you, Abhishek. Thank you, friends. Well, I am the last in the lot where two of my eminent friends have covered almost all the aspects, yet I will try to bring in some perspective in this area of law, which is very dear to me, very close to my heart, because I was the one always would be teased out in the High Court corridor, oh, she's a lawyer of court number 11, because court number 11 was the designated court of which was a company court in Delhi High Court. And obviously now some of the experiences in the NCLB, which is now the jurisdiction of NCLT. So friends, I'm sure all of you are aware that what is the concept of M&A, merger and amalgamation. The concept is, as rightly pointed out by two of my eminent friends, is not new. Since the time immemorial, when there is a trade, there will be the concept, whether it was formalized or not, that has evolved over the period of time in our country. Right since 2013, there was a formal act where there was a concept of, legal concept and a legal stamping of merger and amalgamation. There came 1956 Act, which we have lived till 2013. Under the Act, old Act 1956 and 2013 Act, I have not seen many changes in addition. There are only few clarificatory aspects which have been brought about, and that too by way of the rules. Now, having said that, about provisions under the Companies Act 1956, the provision was very clear. What are the process, motion 1, motion 2. I will not go into the details because two of my friends have already covered that. The three important aspects which would always bother to the shareholders of the listed company, where you are going ahead with a merger and amalgamation, there would be objection. There is a provision of objection now, there was provision of objection then. But company being a listed company where 5% shareholder is considered to be the important stakeholder, which actually help in getting the decision and the resolution passed, they were treated to be powerful. And that is why there was a rule, there was a specific section in that regime, 1956 Act 295, where there was a compulsorily acquisition, and the court had a power to look into if all the stakeholders have given their consent to proceed with the merger or demerger, for that matter, the combination of the two. Then if there is a valuation prescribed for the allotment of shares post merger, then at that price court can force them to sell the shares. And this law was decided on, I can see my friend with whom I really worked in many of the merger matters. My friend is sitting over there, Gopal. Gopal Ramdev, we must have done at least 100 mergers together at that point in time, and this was one of the very intricate and important issue which really took little while than the normal time period of getting the approval done. And that has also been incorporated in the present regime of the Companies Act. Now, earlier there was no concept either in the provisions under the Act or under the rule for the purpose of dispensation of the meetings. This was engineered by us, where we said that, look, what is the purpose of having the meeting? If it's a private company or closely held public company where more than 51% of shareholders are giving their consent for exemption, then there should be exemption, because if you see what is going to happen, the result would be the same. I mean, they may object to the merger scheme, but what is going to happen? The law is very clear. Present and voting, the resolution should be passed. That was appreciated by the court. So if we all are a corporate lawyer, we have to really see how to find a solution before the court. Now, in the present regime, if you see, there is a provision of a rule where it says 100% shareholder has to give the consent, only then there will be dispensation. The matter was argued before NCLT Delhi. NCLT Delhi did not agree. There was a matter in NCLT Chennai, and when it was argued that under the power, you have got a discretionary power to see whether you are doing the substantial justice or just going ahead with the process of law, what should you choose? And it found some merit, and now there is a judgment. Those matters are pending before NCLT to take a call. So these are important aspects. Now, what is the law which we have to take care of it? There are various laws. Control law, as Pooja pointed out, is the CCI. You have to really see if the total combination is coming out to more than 1,000 crore, then obviously CCI has to be approached and permission has to be taken well in time before you go ahead with the filing of the scheme. Similarly, NBFC, RBI, there is a RBI guidelines and RBI circular which says that if you are acquiring the control and the management of NBFC, therefore prior approval from RBI is mandatory. So what is, a client came and he said, look, mine is NBFC, now I'm going ahead, so therefore we'll have to apply. I said, why should you apply? You'll have to really see whether there is a change in control, where there is a change in management. Then you have to really work out, you'll have to spell out in your scheme that this is not the case and therefore I'm not going ahead, not seeking permission specifically. However, as a matter of transparency, I am filing it, I am also sharing a copy with RBI, and that scheme was approved. So therefore, as a professional, when you are going to give the advice to the client, you'll have to really see it differently, how to achieve the objective. Insofar as the types of mergers are concerned, there are various types of the vertical merger, the horizontal merger, reverse merger, conglomerate mergers, mergers of holding and subsidiary. So there are very different kind of schemes where you can propagate for that purposes. You have to have good understanding about how we have to proceed and what is the application of mind. As all professionals, I can only suggest that much. Now, what is the important thing? If there's this is under the scheme of Companies Act. Now there are other schemes where people are doing the deal directly, which is M&A deals, and India has become a very important destination. I was reading, the survey, and I was really happy to see that the direct deals are happening almost 400 deals, more than 250 billions deals. And through the process of accord, there are only around 12%, which is not very encouraging. We should, do it in a manner, because if we go through the court process either under the Companies Act or under the IBC, we get a lot of concessions. We get the stamping where there is a very little, exposure to the unknown liabilities. So these are the important aspects one should keep into mind. Another aspect which my friends have not touched, and I thought it's important to share with all of you, the disclosure about investigation. And nowadays, what is happening is the various companies, whether it's listed, private, or closely held public company, there are various kinds of investigations are going on. Then how you have to approach in the scheme, that's very important. In fact, we got stuck in one of our matters, but I knew the company is going to be merged with the entity, the resultant company, and if we keep the provisions of the investigations going on, there is already SFIO investigation, completed investigation report after taking approval from the MCA. The complaint has been filed before the special court as provided under Act, because the special court has only jurisdiction to look into the complaint. So then the objection came from the bench side. Oh, there is already investigation report. There is a fraud played by you, and how come I am going to allow it? Then we pointed out the scheme that, look, the company anyways cannot be prosecuted for custodial punishment. It can only be by way of, I mean, no doubt there is a punishment, and it's not, we are asking for exemptions of any kind insofar as those who are involved. It's a company's merger, and a company is giving the provisions. It is keeping the provisions very clearly in the scheme itself, that whatever are the proceedings, that will be the liability of the company, merged entity. And we are also not asking for that those companies should not be represented before the special court. If that is so, then this is the meaning of the court, and that is why the object and a purpose of merger and amalgamation. That because of some investigation going on, or some investigations have been completed, that should not be the ground of stopping the merger. All that is required is to give the proper disclosure, and you are not avoiding the liability. Now, the third aspect, which is very important aspect, two of my friends pointed out about the income tax. Prior to 2013 Act, there was no specific requirement under the law to give notice to the income tax. Income tax would always come through RD. Why? Because there was a notification by the Ministry of Corporate Affairs where it would say if anyone has got any department, inter-department objections are there, they should first give it to the Ministry of Corporate Affairs, and that will be proceeded through or prosecuted through or represented through RD. And many a times we've seen that scheme got delayed because income tax would come and object. The very important change in the present regime of the Companies Act is that there is a time period provided, 15 days time. You have to give notice, you have to ensure that the notice is given and notice is received from the date of receipt of the notice. There are only 15 days time to file the objection. And this is what had happened in one of our matters, as pointed out by my esteemed colleague, that they will take number of times, and in fact, Anand also pointed out that they will take their sweet will, but here the role of the adjudicating authority, role of the NCLT is very, very important. You have to point out, look, what is the purpose of giving 15 days time only? If they have not availed that, that should be closed, and this has actually happened, not in one matter, in 20 matters. There were parallel proceedings going on where some of the companies were, this was a scheme of a merger of 20 companies in one company. Few of the companies were having their registered office in Odisha, so therefore the Cuttack NCLT. And Cuttack NCLT members took it very, very seriously, and they said, no, the notice was given, it's more than 1 year, now your right is closed. That was cited here in Delhi NCLT. In Delhi NCLT also passed the same order. SFIO kept on insisting that please give us additional time. So there was a speaking order, and in fact a kind of strictures passed against the RD office that you were given time thrice. Now there is a closure of the order. Now you come and explain why you have not filed your objection in spite of giving time, and after that has also happened, you have not taken any steps, and now you are coming forward again and saying कि आप अपना पिछला वाला order recall कर दीजिए. It's not possible. So the role of our members at NCLT are very, very important. They have to see, if they are the government organization, doesn't mean that they are entitled for many opportunities of granting time. If the court is strict I'm telling you, they'll come forward very quickly, filing their responses. So those are the habits, and those are, the messages to be given and inculcated between the bench and the lawyers. So all of this are important when we are really looking for, the approval within the time period. So the role comes from both the sides, the bench as well as the lawyers. So we both must be, kind of be ready with taking up the matter, giving the proper assistance. And now, as in the inaugural session, Mr. Madan was there, our president was there of NCLT, who is trying to bring out in the format. Two of my friends have already pointed out about it. So those are the things, if we take care of it, I'm sure we will be able to, achieve the target of getting the merger amalgamation in time-bound manner. Now, one important aspect which I wanted to focus on, if it's a listed company, three aspects are very, very important. One is the valuation. Second is you have to ensure that you are complying with the SEBI takeover code, SEBI LODR, SEBI prevention of insider trading. So all these things are also to be considered. So what is the scheme? Scheme is nothing but a contract with the shareholders, their stakeholders, and with the company. So therefore, we have to comply with each law, contract law, Stamp Duty Act, which my friend pointed out, then also Goods and Services GST law, how you are giving, how you are putting the provisions in that. Then also Income Tax Act, we all dealt with it. In addition to that, the shareholders' right and the creditors' right, how we have to ensure that their rights are not affected in any manner. Merger and amalgamation is the tool which has been provided to give the impetus to the growth of the industry. At the same time, it should not be that it is a tax avoidance. If it is a tax avoidance, if it is a colorable scheme for the purpose of a tax avoidance, the court has come heavily on it, and this is a settled law that is the reason that when the income tax would come in the previous regime coming forward, that look, my right is getting affected because it's not a tax efficient, it is a tax evasion. If it's a tax evasion, then the court should not sanction the scheme. So therefore, if it is not tax evasion, if it's a tax efficient, you should be ready to explain that how it is tax efficient. And if all these things are taken care of, I'm sure the court will come to your aid. And insofar as direct deals are concerned, there are only three aspects which people have been doing it. One is the due diligence, proper due diligence, where you will have to see if you are targeting a company for the acquisitions, what is the kind of due diligence one has to take, where there are various financial due diligence, legal due diligence, social due diligence. And ESG is a very, very in thing these days. Earlier it was only the box mark, but now people are actually working on it, and they are ensuring that there should be less carbon emission if you are doing the merger amalgamation in manufacturing industries. Now the startup, I'll close it. I know I'm taking a little more time. I'll close it in a few minutes. Now, this merger amalgamation tool is also very, very helpful and important for the startups. And in fact, the data has shown that these small startups, they are able to pull through some of the investments. And once it has got a potential to grow the business, the bigger business are coming and they're acquiring it. So that has also helped in the growth of the industry. And after post-COVID, we've seen 5-6 industries are actually going very vigorously in terms of merger amalgamation. It's media, entertainment, power, renewable power, your manufacturing, realty, banking, and telecom industry, where we've seen deals, mega deals have been done. Some of the conglomerate deals have also been done, which all of you know. Adani recently acquired. your Reliance also acquired, but some of the smaller deals like Paytm and all that is going on. So this is a very important tool and very important, the tool where the legal support is required, and for that there is a well-placed legal system. All that we have to be we have to make sure that we are, very carefully drafting our scheme. We are carefully taking consent and the approvals at the right time, and then there is a no looking back insofar as the approvals are concerned. Thank you very much.
Thank you, Ms. Gawai, for giving us all these insights into various aspects of valuation, mergers, and most importantly, the disclosure of investigation before the courts. With that, I thank all the eminent speakers on the dais today. We have taken note of all these suggestions which have come through, and in fact are very important for the speed in which the schemes under M&A are required to be approved by the NCLT. With that, I now call Dr. Jatinder.
We have decided to prepare a white paper, and I would like all the panelists to represent us before the
Exactly, this is what we discussed in the morning with Mr. Madan. And thank you very much. May I request Mr. Madan to kindly come on the dais and felicitate our guests with a memento and a plant from PhD chamber. Mr. Abhishek, please. We'll have one group photograph. So, ladies and gentlemen, we break for tea, and we are breaking only for 15 minutes. Kindly be on time, and we'll be, in fact, I think, amalgamating both sessions together.
Yeah, post lunch we are going to merge both the sessions.
Post tea break.
Post tea, sir, post tea, before lunch, yeah.
वो ले जाएंगे मैडम आप
अभी थोड़े इधर को करना पड़ेगा मैं मुझे जरा इधर आ सब हो गया अब एक टेबल पे दो लेकिन एक टेबल पे दो इनको सेट करो एक टेबल पे दो हो
एक दो
इधर आ जाएगी एक टेबल
सब आ गया
इधर तक आएगी
भाग इधर दे
फोल्डर्स में ठीक करो हाँ सर आ रहे हैं
बोल सर और एक चेयर भी चाहिए
उस साइड लगा देना आगे से लाना एक मिनट
अटेंड मैं कर रहा हूँ कोई दिक्कत नहीं छोड़ दे
थोड़ा सा इसको ना ओवल कर दो बोला ही नहीं होता ना ना फ्रंट पर डाइस को थोड़ा हमेशा कभी इधर करना क्योंकि ऐसा ना मांग रहे हो
इधर कर दो सर इसको थोड़ा
थोड़े से टेबल साइड
ये दोनों सेशन के अभी बता दो
ना करके मस्त करते
उसके भी रिमोट कर दे
पहला सेशन बहुत लंबा हो गया इनॉग्रल
हाँ डेढ़ ठीक है एक चेयर चाहिए
Good afternoon, ladies and gentlemen. May I request everybody to kindly settle down, please, and also request all the speakers to kindly come on the dais, please. So we're talking of merger and acquisition, so we are merging two sessions together. Well learned. The lessons of the first technical session.
It is basically application of what.
Yeah, application, exactly. Exactly, that's very important. May I request everyone to kindly settle down, please. So, without any further ado, I'll request Mr. G.P. Madan to kindly be our session chair and please start the proceedings. Over to you, sir.
Thank you, Dr. Jatinder. Welcome back, dear participants. Now we are going to, actually we have decided to merge both the technical sessions. First technical session post tea break was on the CIRP process, role of NCLT and NCLAT in that. And the next one, applicability of section 230, that is a compromise or arrangement in case of liquidation of a corporate debtor. What are the practical issues and challenges? First of all, I'm going to start the session on CIRP. And though now we have merged the session, so all the participants are, all the panelists are allowed to interject or intervene on any of the issues. Yeah. But keeping in mind the timelines, because it's already now 1:35 and I propose to end the session at 2:40. I think इतने में काफी हम अपनी बात कर पाएंगे. And in this session, one thing we need to take care that infrastructure issues and the members issue has already been dealt with in detail since morning. So those issues we are not going to discuss. The number of members are come. There is a delay happening because of adjudicating authority. Infrastructure is not there. No, we will not discuss. And moreover, we are not going to the details of the issues at the level of COC and all that. What we have to going to deal with here is issues relating to concerning CIRP with respect to the adjudicating authority only. We need to travel beyond that. Otherwise, the CIRP issues we can discuss for weeks together. Everybody, all the panelists are so experts and experienced. So I would like every speaker to speak for 10 minutes. And then at last 10-15 minutes, I want to throw open for questions and answers, because I'm expecting number of questions from the participants. M&A, all the participants are not dealing in M&A, but majority of you are dealing in CIRP. And some of you are having issues in liquidation also. So my first speaker is Mr. Anil Kohli. Sir, over to you.
So
If you want to speak from there,
I
the choice is.
I think we should actually try to sit here only, because in case we try to go
Sir,
to the
I'm
mic.
leaving it to the wisdom of the faculty.
Otherwise, like, it may take a little longer time. Because see, like we are 6 altogether. I think
मतलब
sitting
खड़े
here
होके
will be
बिठाना
better.
मुश्किल है
हाँ,
अगर खड़े
खड़े
होके
होके बिठाना मुश्किल है. In between.
यहाँ से माइक छीनना भी आसान है.
और वही मदान साहब साथ में बैठे. So good afternoon, everyone. So regarding CRP, I won't say much because everyone is aware of that. It's a corporate insolvency resolution process. And I would say, yeah, this is the best possible mechanism for a company which is a going concern, a running company. So here I am specifying for a running company, because you know what has happened, why I think there are so many issues which are arising in this IBC, which we are all talking about, that there are definitely some things which need to be corrected to make it more successful and more in the direction of achieving its goals. What I feel is that first of all, there should not have been such a immediate enforcement upon each and every company with such a small amount of 1 lakh of a default and all. So which has created a the number, the volumes which are difficult to handle with this infrastructure. So I won't speak about the infrastructure. So NCLTs definitely are overburdened. So that is one thing. However, one more thing which comes to my mind to enlighten the burden from the adjudicating authorities, what can be done is some of the processes are unnecessarily going to be to the adjudicating authorities, like filing of progress reports. This doesn't need to go to the adjudicating authority. There is nothing for adjudication before them. So, and replacement of resolution professional. These fine, admission of a process is one thing which can be decided by the adjudicating authority. Liquidation is another thing, approval of a resolution plan. So certain these kinds of issues definitely need interference of adjudicating authority. But these administrative kind of things, extension of time and replacement of RP or these progress reports, these can be handled by IBBI also. So this is one way, I think, which can be proposed to enlighten the burden of adjudicating authorities, and it's additional to what we are talking about, the infrastructure. Second, because Mr. Madan has limited myself, our role to speak only about the adjudicating authorities in CRP process, then comes section 19.2. Section 19.2 is the, I think, most largest volumes with the adjudicating authority. So what happens is, this comes from another cause. The cause is because the RPs, they do not find any, recourse, any kind of, I would say a kind of, respite from any direction. What they would see is only to look towards the adjudicating authority for addressing their concerns. Because, once you do not do that, so what happens is you would be called upon. What action did you take? When the issue was before you, the directors were not cooperating or the management was not cooperating, like why you have not finalized the accounts? Fine, you file a 19.2 because the directors or management did not give you the information. Like in one of my matter, CBI questioned me for this, that, okay, where are the books of accounts of the earlier periods? So, sir, I said, I do not tick mark each and every document and say that, okay, I have taken into custody for, following vouchers or the books or all this. Fine, this is with the, as it's a going concern, it's a running 5-star hotel. So fine, it's with the management, it's definitely must be there only. I won't tick mark. But he says, no, you should have called upon all this. And where is the 19.2 application? So fine, I said, okay, nice. What I did is, I sent a mail to the management, fine, I need all these records, last week itself. So fine, I filed a 19.2. So your concern is addressed. I am also now feeling relaxed. Okay, fine, you needed a 19.2. It's there. So this is actually adding to the burden of the adjudicating authority. So some things need to be, the entire stakeholders here, to enlighten the burden of adjudicating authority, the stakeholders need to be educated. They need to be educated like the promoters, directors. What would be their role? So they generally shed away themselves from all the responsibilities, and they would say, fine, now the RP is the whole and soul in charge. RP has to look after each and everything in the company. So we don't have anything to do with, even, the regional director is going to give you notices for even for prosecution proceedings and, asking for all informations, like you are the person. Even in MCA, they didn't know that, RP's directors are still duty bound. Only the powers of the board of directors are suspended, because they are telling me, okay, they are suspended now, so you are the person. No, the directors are not suspended. So if these people are educated and they know, yes, specifically this is their role and they have to cooperate, and what all cooperation and what will we see, the RP himself cannot run each and everything like business, or running of the taking care of the compliances, running of the process from claims, invitation, resolution process, then each and everything. So there should be a role defined, at least for the management, what they have to do, what is how they have to continue, because they will say, okay, this is the loss in the business, you are responsible, the RP is responsible. No, you can only supervise, you cannot do each and everything. So what happens is, now RP calls for their cooperation, and they say, no, we are not in the role now, so we are not at all accountable. So the RP will file a 19.2 application. This adds to the burden of the adjudicating authority. First of all, the role of the management, ex-management, I would say, or we should say management. They are not suspended. Management is still there. They have to run the business. RP will only play a custodian role or a supervisory role. So first of all, them, then the authorities. The most of the 19.2 or the claim rejection or all involvement of RPs comes from the taxation or the government authorities. They would keep on filing something with you and asking. They should know. So what would happen? What is the process they have to take care? How the assessments will be carried out? How they will enforce the penalties? They are just putting on penalties, like adding on whatever as per their wishes. So they need to know that, yes, this is the way they should run out. These people should also be educated upon what is their role. So there also some volumes will go, low from for the litigations to the adjudicating authority. Then the COC. So the creditors themselves, even the RP sometimes doesn't know, about the claims. He will say, okay, fine. One way you are just collating the claims. How to deal with, like bank guarantees or the FDRs which are kept as margin, and what will be the creditors' role in approvals for certain things. Then there is a litigation about that. So these kinds of things also, this COC also needs to be educated, and I think this all comes from the concerned authorities like RBI. Not IBBI cannot enforce anything upon this kind of stakeholders. The taxation authorities, it should come from the CBDT or their regulatory authority. Regarding the stock exchanges, it should come from SEBI, and regarding the COC, it should come from RBI. So this definitely needs to be taken care, that all the stakeholders are educated, so that there are least litigations, and which can definitely decrease the burden from the educating authority. Then comes, about, I would say, I cannot speak about the infrastructure. That would definitely there. Then 92, I have to restrict myself to that way. So then comes the resolution plan approval. What I see in the end of the day, adjudicating authority has to just take, it's taking on record, I would say. They would definitely say the plan, since Supreme Court has also ruled that it is the commercial wisdom of the COC which would prevail. So the adjudicating authority should take time involvement in the plan approval process as per, I think, in the light of that judgment. And they don't need to, I think, go deep into all that. And this can be, adjudicated upon as at a faster pace. So this is one thing. Then admission definitely they should only look for the default, and that okay, it's not my domain to educate them, but I think certain these kinds of things is required to train or educate all the stakeholders, which would definitely reduce the possibilities of litigations. With this, I'll end my 10 minutes.
Thank you.
Thank you.
Thank you, Anilji. You have said that in some of these application 19.2, progress report, replacement of RP, extension of time, they should not go to the adjudicating authority. Where should they go? IBBI. I think IBBI, you are going to give the regulator the adjudicating powers. I think this may be a dangerous situation also.
There is no adjudication required in all these processes. They are just registrar, yeah.
Registrar of NCLT. अभी तो registrar भी नहीं है वहाँ पर. And I tell you, looking at the disciplinary proceedings which have been initiated by IBBI against the insolvency professionals, in my opinion, filing of 19.2 application and filing of avoidance application should become a ritual. If you do not file it, you will receive a show cause notice from IBBI. But why have you not done so?
That is what is increasing.
And now you want those should be filed with IBBI only.
No, not 19.2.
Yeah.
Not 19.2.
Okay.
19.2 is to be with adjudicating.
And as far progress report is concerned, some adjudicating, some benches are accepted or taken on record with subject to just exceptions. And some benches are going into details of these progress report. And that is also actually taking a lot of time.
Recently, there is an amendment where the progress report has to be filed as an application.
Again, no, but even as on date, there are divergent practices before various benches, whether it should be filed as IA or otherwise. Filing as IA, there is only one concept, one reason, that along with IA, you deposit an amount of 1,000 rupees. That is the only thing. So they should make it mandatory along with the progress report, you'll deposit a fee of 1,000 rupees. But for that, you need to change the NCLT rules also. Okay, there are other issues also, but I'll restrict my views on this. Now I invite Mr. Anil Goyal, Chairman, Triple Insolvency Professional LLP.
Thank you, Mr. Madan. I think we have to restrict to whatever has been told by you to remain like what are the difficulties that we are finding before adjudicating authority in CIRP or a resolution plan. So what my understanding is that in case we look at the objections which has been filed by various stakeholders against a resolution plan, that would be right thing to discuss by me, because I think other things have already been spoken by Anil Kohli. So I think the conditional resolution plans is one thing which is objected, and we are all very careful that the conditional resolution plan should not be submitted. However, in the case of this airlines case, Jet Airways, this was the first resolution plan which was admitted as a conditional, because one of the condition that the license of the airlines that would be renewed, that was the condition, and that was admitted by the NCLT. So similarly, we can assume that if the resolution is depending upon a key issue, that key issue can actually be made as a condition. So that should be acceptable to the adjudicating authority. Then the resolution has to be compliant to all laws. Nobody can say in the resolution plan that in future there will be some waivers or some exemptions from GST, from any local laws, or from any income tax, as we used to do in BIFR. So that kind of options are not available in resolution plans. See, the biggest dispute that we have seen so far is from the dissenting creditors. Because see, the dissenting creditors are saying that my liquidation value has not been provided in the resolution plan. The reason being, the dissenting creditors say that I have a security interest on an asset, and the value of that asset is X, and I have not been offered that X value. That is my objection. And yes, I think this issue is actually pending before Honorable Supreme Court, that in the case of Technology Development Board versus Kotak Mahindra Bank or Stressed Asset Fund. And this issue is like whether Section 53, the interpretation of Section 53 is whether the priority of charges and the value of security interest would be considered while allocating the liquidation value or while allocating the proceeds of realization of assets to the stakeholders. So this is a very important, because so far this has not been resolved. That is my case, because originally this is the only case in the country where the allocation was done as per the Insolvency Law Committee report dated 26th of March 2018, and also based on the Supreme Court judgment in 2005, Sidco Leather versus ICICI Bank. So based on that, adjudicating authority at Ahmedabad, they gave us a positive order. However, NCLAT said that in section 53, we could not find any category. So it is only one category of secured creditor. We could not find any category for the first charge holder, second charge holder, or subservient charge holders. We also could not find any special category where the value of the security interest has to be considered. So while the dissenting creditors say that I am entitled to the value of my security interest, the resolution applicant or even the COC says that it will be allocated as per section 53, which is the NCLAT judgment in the case of Technology Development Board versus Anil Goyal. So this is the present dispute which is prevailing, and in most of the cases, the dissenting creditors are not getting their dues, which is equivalent to the value of their security interest. So this is also one of the difficulties that we are facing in resolution plans during CIRP. In various real estate cases that we have seen, the difficulties are regarding the delayed submission of claims by the home buyers. So all these delayed claims, like we have seen, hundreds of applications are filed after the resolution plan is approved by the Committee of Creditors. The adjudicating authority is not inclined to reject all of them, because that is their hard-earned money and they have given money to the builder. So in case they have not submitted their claim, it is very difficult for any court of the country that your 50 lakhs is gone and you will get nothing now. So that is, in fact, I did a webinar on delayed admittance of claims, and I actually analyzed various judgments. So I saw that there are positive judgments when there is a case of class of creditors, maybe debenture holders, deposit holders, or the home buyers. There is a positive judgment, and it is a directions to, always there are directions to RP to admit their claims. And there are negative judgments as far as the operational creditors are concerned, but there are still positive judgments regarding the government authorities. Because see, I analyzed various 20-30 cases where the delayed claims were filed. So in case we try to understand the operational creditors, it is easy to reject. The government authorities, the NCLT, the adjudicating authority says that you, as RP, you should have seen the litigation, you should have seen the books of account, there may be some provision made in the books of account, you should have admitted according to this. So what now we've started doing in the real estate cases, that in the resolution plan, we also make provision for all those who have not submitted their claim. So we are actually saying in the resolution plan, to avoid such kind of litigation, that even after the resolution plan is approved, in the next 90 days or 180 days, whosoever will file their claim, those people, those claimants will be treated like this. So with this paragraph, now we are thinking that all these litigation actually can set to rest, and it is very easy for the adjudicating authority to say that already it is provided in the resolution plan, you can file your claim now and you will be dealt with as provided in the resolution plan. So then the other case, which is the land owning authorities like Noida, Greater Noida authorities, they actually have been objecting to the resolution plans where they've been considered as operational creditors and the value offered to them is much lesser. So that is also a case that we fought tooth and nail, and my partner's name, Anand Sonbhadra, is the case name. And in the case of Shubh Kamna Buildtech, Anand Sonbhadra, that is the Supreme Court finally decided that Noida Authority and Greater Noida Authority or any kind of land owning agencies who have given the land on lease, they would be operational creditors. But there is a separate issue now where the land is not owned by the corporate debtor, and it is a joint venture between the landowners and the corporate debtor. In those cases also, NCLAT has given a judgment that the landowners, in case they enter into a joint venture, they are rather partners, they are rather promoters, and they are not creditors. That also has been given. However, when IBBI gave me the responsibility to go and provide some kind of understanding amongst the Noida Authority and Greater Noida Authority, so I took various classes, and the consensus which is now coming up is, and even this another urban conclave happened at Gurgaon, where most of the builders and most of the RERA chairman authorities came. So now which is something which is common, is that we should consider the landowners, we should also consider the secured financial creditors, and we should also consider the home buyers. So these are the three key stakeholders in a real estate cases, and then we should try to do an arrangement amongst all of them. Otherwise, this litigation would continue, and this would never end. That is the consensus. Even authorities are also saying that, yes, this is the right way, that in case all three can sit together and do this. Then the questions which are being asked by the adjudicating authority, that in case the resolution applicant is offering some amount in the resolution plan, the adjudicating authority is saying that identify the resources, how would you make the payment? Because most of the contraventions of resolution plans are happening because the resources were not seen by the by the COC, and finally the resolution applicant could not arrange funds. So the adjudicating authority is insisting that you should provide us some satisfaction that the resources have been identified. And the other thing which is being asked by where is the recording of the committee of creditor, where the committee of creditor has considered the feasibility and viability. And also at some point of time they are asking, where is the business plan? How would you revive the company? So in most of the resolution plans, please make sure that the feasibility and viability, there should be a special note in minutes, or if not, then there should be some business plan also. In some of the adjudicating authorities, I have also seen how you are in the resolution plan, how you are attending to the cause of default. The basic cause of default has to be attended to, and how it has been dealt with. So that is also one of the issue that has been considered. In few cases, we have seen where the liquidation value is too low and the value of the claims is too high. Now, suppose a company with 1,000 crores of claim, if a liquidation value is 50 crores, the adjudicating authority is asking, we need to understand where this 1,000 minus 50 has gone. If the RP has filed the transactional applications, and what is the amount that you have submitted there, and how much is the loss that the company has claimed. Now, in such cases where 1,000 crore is the total claims, and even this interest is not very high, let us even understand that the principal amount is 750, the liquidation value is 50, and the losses in the balance sheet is only 250. That clearly means that there is a gap of about 450 crores, and the adjudicating authority have started asking where this gap has gone and how the RP has seen it, whether the RP has filed any application under section 43, 45 or 66 or 49. These are also various questions which are coming when we submit resolution plans. I mean, there are many things that I can further add, but I think, Mr. Madan, I have to just go by your direction that I will not take more than 10 minutes. I hope that I have already completed. Thank you. Thank you very much.
Thank you, but in these 10 minutes, you have raised more than 10 issues. That's fantastic. I just want to discuss one issue out of this, that the dissenting creditors, they are not getting their dues. Now, after this amendment and post Amit Metallics, what do you think should be the right position? What is the interpretation of the provision as well as the judgment?
Amit Metallics is also primarily has not attended this issue. What is the interpretation of section 53? I have read this judgment clearly. Section 53 has not been dealt with in Amit Metallic. In Amit Metallic, there are other factual difficulties. When Amit Metallic came to Honorable Supreme Court, at that time it has already passed 1 year from the approval of the resolution plan. Now, when when some kind of case comes to Supreme Court where the resolution plan was passed a year before, and now somebody is claiming this dissenting creditor's rights, So what was the option available with the Honorable Supreme Court? Either to disturb the entire resolution process and do it again, or probably ignore that Section 53 issue and say, okay, whatever has been given to you, that is okay. That is the, in case you would see this judgment clearly, that particular hearing happened before the Supreme Court after 1 year of the approval of the resolution plan. So that is not something which is attending to Section 53. Rather, in the case of JP Infra, where the Anuj Jain was the RP, that has been a better judgment that you can't drag the dissenting creditor into a resolution plan, because in the resolution plan it was said that you would be getting these many flats. So the flats are not available today. The flats will come after the resolution plan is implemented after 3 years. Now, that means the ICICI Bank said that they are dragging us in the resolution plan.
Yeah. So I will just like to add here, because I have been the part of the COC in the JP Infratech, and this was not the issue which was not flagged during the COC meeting and when the resolution plan was actually considered. So ICICI Bank continuously, and we had from morning till night meetings on this particular issue, that what will be the treatment for the dissenting financial creditors, and ICICI has been flagging it throughout the process, and it has been actually put on hold or just not been, considered or something like that. And now it has been, kind of dragged into the court for so long now. So I don't know, like, again, how they are going to interpret the Section 53 is very, very important. And in fact, it should be taken care while the resolution plans are discussed in the COC meetings. One should be aware of that, yeah.
What is your final word on dissenting financial creditor?
So definitely, I think I would say we have to consider it when, if actually the liquidation happens, we have to consider Section 52 while we are deciding about Section 53. So in the case of liquidation happens and the secured financial creditor has the right to, kind of hold its security and, kind of realize it and in Section 52 and not being the part of the estate of liquidation estate in Section 53, then definitely if we take that from there, they should be given their dues, like they should be able to have whatever security they have, say, for example, given in the plan if they dissent at all. Yeah. Yeah.
Madanji, I'll just add one more thing. See, the very important that we have seen various orders where the resolution plans are being approved. I have to just see the format which has been given by Honorable President, what that format is. However, I think the most of the members have started saying that for this you go to this authority, for this you go to this authority, for this you go to this authority. So what I understand is Section 53 is very powerful under IBC, and this is not under Section 230, it is only under IBC. When we go for 230, there is nothing, no such waivers. See, Section 230 is very clear in waterfall arrangement. If your water finishes at this level, thereafter everything is waived. This is regarding the financial claims. Like, I am not saying, like, when we talk about the income tax brought forward and setting of, as for the set of past losses, that is something for the future. When we say the RERA authorities will sanction my plan, that is for the future. So NCLT is not approving anything for future, but as far as the existing claims are concerned, everything should be finished if the money is not available. Even those kind of orders are not being passed.
Regarding this dissenting creditors, I would like to say this is becoming a very major impediment in approval of the plans. Yesterday, I got a call from ICICI Bank that now we have two options. Either to, consider for getting a liquidation value when the plan is approved as a dissenting creditor, or to get into the approval of plan. Yeah, all the creditors have these two options. If they consider this kind of option, plan will never get approved, because if it's below the liquidation value, or if one of the person has a secured, a priority of charge, then definitely this will become a major problem. So there needs to be clarity on this subject, and also mainly on the subject of priority of charges. This issue of priority of charges is needs to be decided upon, because there are conflicting judgments of NCLAT in this regard. So there needs to be a call from Supreme Court.
There is only one judgment so far. The NCLAT has given, in fact, because it is for NCLAT, once they have taken one view, which was taken by Justice Butt, now the NCLAT will have to follow that till the time the Supreme Court decides the other way. So in case any other bench also takes a different view, that means even the first judgment which was passed is kind of like
I think we are having now divergent views on dissenting financial creditors also, and I can assure you that every faculty member sitting here, every eminent speaker is willing to speak on this. I can understand Makija ji kaise chup baithe honge, I can understand. I think Abhishek also wanted to speak on this. He also picked up the mic couple of times. This is an issue close to heart of everybody who's sitting over here. But I think it's very difficult to, otherwise we can speak for hours also on this particular issue. Now,
forfeit transactions are also something which is now it's being asked. If the transactions, if the applications are pending, the resolution plan should be approved or should not be approved. That also has actually been a very, very big issue. Now, the amended regulation says that the application has to be filed before, and the copy of the application has to be given to the RAs before even they file the resolution plan. This is the new regulation which says like this. So for all the insolvency professionals, it is mandatory that right from the beginning they should work on the transaction audit and also prepare the IAs wherever it is required, and then pass on these copies of the IAs to the RAs. This is the requirement, latest requirement as per the regulations.
so though I want, but I'm keeping my remarks reserved on this. Yeah, Mr. Sunil Gupta, please, now, your views.
Sir, thank you very much for the opportunity. And I think a lot of things has been already been told by Kohli Saab and Anilji. I'll just add 2 or 3 things into that. One is the power of COC members, which has been asked by all the circular by IBI that the COC member who is coming, who is attending the COC meeting should have adequate power to decide. But in fact, they don't have, and they continue to be saying that we'll take the decision later on, let this come for the voting, and we'll decide. Even the resolution plan, they normally need to 15 to 20 days time to get the approval of their competent authorities in time, and that is a practical approach because ultimately their HOD's head office is deciding on the resolution plan. I think that to that extent there is some dichotomy in the process. Second is what Anilji said is regarding the funds, the provision of funds in any resolution plan, source of funds. Now, there is source of fund. I may say there is equity that I will be coming or the internal accruals that I will be generating during the process from the corporate debtor as well as from the resolution applicant, depending upon the timing of the payment. Now, the timing is not defined. Now, you may make the payment in 10 years, you may make the payment in 2 years. And if we see the NPV again is something which is a number. I may have a payment in 20 years with an NPV of 10,000 crores and payment in 1 year an NPV of 1,000 crores. With 20 years, the risk definitely increases multifold. So again, it's a problem where funds have to, your sources have to be defined. Now, if I say a source, now if I have to give a source, again, there is a business plan which has to be supported by some Excel model and supported by the assumptions, past assumptions versus new assumptions. That has to be vetted by the COC members to check the viability of any plan. This is a challenge because in the plans, nobody is giving any projections. Only the projections of some numbers are given and as a part of the plan, but soft copy of the plans are not available. Secondly, the challenge of sources. For example, if I say I am having the capability of raising funds, then the problem is, should I get the sanction today? I am not aware whether this plan will be approved or not approved, and I am getting the source today, then this sanction goes out. And if there is a letter of comfort from the banks or any financial institution, we don't know to what extent it is valid.
They are non-committal almost.
Exactly. So they are a non-committed fund, source of fund, or any letter of comfort that anybody is giving, even the related party, if it is giving, we don't know whether it is going to happen or not. So definitely that is a big challenge for viability, checking a viability in any plan. Third is what we are finding in the plan is people are not aware exactly what to do, how to deal with the various liabilities. As we were telling about the operational creditors, like I'll give you a very glaring example in which we were dealing. There were PF liabilities which were shown or gratuity provisions were shown in the balance sheet. Now the employee claims were not there. Absolutely no claims from employees were received, and gratuity is in any case has to be paid to the employees which are operating today. It's a tea estate where thousands and thousands of employees are working, and they have not submitted any claims because their current pay dues were paid, no gratuity dues were shown, and the gratuity dues were in the balance sheet. Now, effectively what happened that in the resolution applicants were aware of the fact, and that's why they provided some money towards the gratuity. Had it not been then that liability goes off. Now, how it to be dealt, it will be a big challenge. So people are not aware of how to deal with these types of subjects in the plans. One more thing which I would like to add, the challenge in a resolution plan is, or a during the CRP process, is the lack of knowledge by the civic authorities or the police. Now, if I have to take a possession of a thing, if an asset and CD is not helping me, one option is that I should go to for 19(2) and get a possession, or I should ask that the civic authorities may be asked to get the possession or help me in getting this possession. Now, if I go to the police, he says, okay, fine, get me the order in my name only, then otherwise just keep this order aside. I'm not entering into this. And and then there is a loss of time. Important is, one is the NCLT is burdened with the new applications, and secondly, there is a loss of time. And considering the time factor that we are already struggling with because of the various challenges as we have discussed during the entire course of day, so time management becomes very difficult for any RP to meet those timelines. Then litigations, definitely we have discussed the litigations. We have also found the agitations, post-approval agitations by workmen particularly, because for workmen, normally people are not keeping. Now, that is where I think the regulators or the lawmakers have to see, if we have to secure the interest of the workmen, then workmen have to be given priority, and the entire amount should be given rather than a portion of that, because they say they are pari passu with the secured creditors. Now secured creditors may be getting 20% and they are happy with it. But for workmen, it is a lifeline for them. And I think this is my personal view that they should be protected. Either should be protected or should be then because resolution applicant who is a successful resolution applicant should not be debarred from taking over the asset and operating the way he has been approved, the plan has been approved.
I think at that stage, the resolution professional should convince the COC as well as the resolution applicant, at least workers' dues should be taken care of.
Sir, I agree, but the thing is we cannot force. As an RP, we cannot force.
I'm not saying force, but he should try to convince both.
Exactly.
The parties,
the point is sometimes the magnitude is quite high. I can tell you in one of our cases, we got workers' claim of 5,000 crores. So there were 14,000 workers and we got 40,000 workers claims were received, and the claim was 5,400 crores. Now the plan was only 375.
Were they working without wages with the corporate debtor?
No, whatever you say, no, that is a different issue because that claim was rejected because they were not supported. But my point is the agitation may happen once the resolution plan is approved. Because it's tea estate, and tea estate, okay, there is 4,000 to 5,000 workers which are working in each tea estate. So these are the problems, challenges that.
I'm just raising a question to you. Mr. Anil Goyal raised a question of this feasibility, viability, funding arrangement, and business plan, and attending to the cause of default. Should it be kept to the jurisdiction of COC, or should the adjudicating authority look into all these aspects?
Sir, my view is COC should look into it, but the thing, in any case, the viability has to be checked by COC. Now, problem is that because of the lack of information, first is because there is no format. I think the format has to be devised, and format has to be given to the RS, that this format is given, and this is the minimum information that you have to provide. Like cause of default, one of the reason, and a lot of people are saying the cause of default is there. But even the RP doesn't know what is the cause of default. Now, how can you assume that the cause of default is normally what we are saying, as Mr. Anil was saying, that for 2 years, we can, in the plan, in the code, it is the look back period is 1 year or 2 years, as the case may be. Now, the inventory is stated for last 15 years. How can you go 15 years back? You are not allowed to go to 15 years back. So what you are saying is, it is the prerogative of COC to see the viability of the plan, but there should be adequate information which should come into the plan so that the viability can be checked. And that's why it can be recorded in the minutes. Yes, we have checked the viability. Maybe in the second minutes, later on, once the plan has been discussed, maybe later on they can internally check and then they can come up in another meeting and they can say, okay, yes, the plans are viable. These
My
plans are
request to
viable.
why don't you devise a format and give it to IBPay so that IBPay come out with the regulations
I think, sir, we will be very happy to provide some.
please do that. We can all help you out and we can
Sure,
go to
sir,
IBPay and
sure, sir.
recommend our case.
I'll discuss with you.
Thank
and
you.
then-
Thank you so
sir.
much.
Thank you very much.
Thank you. Now I'm going to reverse the role before coming to section 230. Whatever the issues have been raised, couple of issues I'm going to raise to the other co-panelists who have not been part of this program so far. Makhija Saab, Mr. Anil Kohli raised an issue of this filing of these, not filing application with the adjudicating authority, but it should be to the board. So you know you are wearing two hats, as advocate as well as insolvency professional. What are your views on this?
Okay, see, as far as the status reports are concerned, particularly in liquidation, now we are talking about preliminary reports and the quarterly reports. Let's understand, adjudicating authority is the supervising authority. There is no COC. Stakeholders committee, of course it is there, their roles have been increased over a period of time, but they don't have any, they have only recommendatory powers. So at the end of the day, the liquidators are kind of reporting to the adjudicating authority. And this is the same scheme which is following from the Companies Act. Because in winding up, the official liquidator who was there, now he was always asked to file a status report before the next date of hearing. So filing of a status report to the court is not an empty formality, friends. It is something which is serious because it will also protect the liquidators also. Because if you have already covered something, probably you might not have filed an application, but you have covered something, I think it will protect you in times to come. So in my opinion, I differ with Mr. Kohli. I would say that let it go there because it's at the end of the day what the courts are saying. I mean the adjudicating authority in most of the cases. They say we take it on record subject to just exceptions because that's their job to do it. Now, whether it is filed as a part of the application or just like a status report, I think they are following the judicial process. In the High Court also, they were a part of the application only. We had to file as an application only. Otherwise, registry cannot recognize it. Number has to be given. Unless the rules are changed, as Madan Sahab said, unless you change NCLT rules, well, this is the process which you must follow.
The issue is, actually, I forgot I'm sitting between the lawyers, you know.
Both of us are IPs also.
Major issue is
Now, Anju, I'm going to raise a very tough question to you. Mr. Anil Goel said that plan has to be in compliance with section 30, subsection 2. And all of us have gone through the recent Supreme Court judgment of Rainbow Papers. If statutory dues, government dues, any legal authority dues, or any other authority's dues, if they are not part of the plan, this plan is not in compliance with section 30, subsection 2. So what is your take from on the times which are going to come now? Wherever the plans are already before the adjudicating authority, already before COC, or the plans which are going to be submitted, do you think that this issue can be dealt with in the resolution plans, and all those plans where the dues have not been provided, they should be treated as non-compliance of 30 subsection 2?
Yeah, so I think for me, like after this rainbow judgment came, main issue is the treatment for the operational creditors who are not sitting in the COC, first of all. Because what is happening, and it is from the day one, in fact, after like IBC came and we were seeing some resolution plans and where the operational creditors were not getting their dues. So I will come later on the statutory dues. I will first, handle the issue of this operational creditors who are not coming in the COCs, and COCs are not taking care of their, I would say, interest They are not protecting their interest in the sense because they are voting on the plans. So from the day when I'm saying that even if the financial institutions are required to take their money back to be or to remain solvent and do not go into bankruptcy, same goes for the operational creditor. And I think today only in the very beginning, in the first session, I don't know who said that MSMEs, which is the backbone of the economy, who are the operational creditors to these corporate debtors who are going into insolvencies. Like we saw the largest 12 big cases coming up, where I'm sure at least, if not less, 100 or 200 MSMEs who are, kind of providing them support services and goods and services, sorry. So it is very, very important to make them relevant and to make them solvent, that their rights or their interests should be protected in the COCs. Now then comes the treatment to the statutory dues. So my humble submission has always been there, and as RP, I have tried to convince my at least COCs that if not, given them their everything or a major proportion, at least something should be given. So if something is given, definitely they have been dealt with, means the debt has been dealt with. And in the going forward, if we kind of resolution, when we are talking about resolution plans, and we are talking about the section 53's application in the resolution plans also. So then those have been already been dealt with in section 53. So statutory dues, operational creditors dues, if the code or the BLRC committee or the makers of the law have already put them somewhere in the section 53. So why we have to, kind of bring that together again and again? In fact, more than the statutory dues, we need to take care of the operational creditors who are not sitting in the COC, who are small business owners and who are very, very relevant for the economy per se, as a developing economy. So definitely this rainbow paper, because in the rainbow paper issue is not only this one, because the lead banker actually had called me, who was there in this case, and the plan has been contravened. He has already demerged the entity into their own entity, and they have sold the assets of the demerged entity then. So there are so many issues in Rainbow, and not all the parties were there in the Supreme Court judgment in any case. So not all the stakeholders were represented there in any case. So there, I think it will be opening a Pandora box. One more aspect which I saw as an entrepreneur, as a resolution professional, at the garb of not providing to operational creditors, none of the stakeholders actually getting benefited from the resolution plans. The only one person getting benefited is the resolution applicant, because then at the garb of the law or at the garb of the the provisions, he can actually extinguish all the debts, and good assets have been bought in exchange of peanuts, I would say. So there we have to be very mindful as resolution professionals and COCs, that what the inherent value in the corporate debtor, and accordingly the price should be determined for the corporate debtor, and the plans which are actually providing for that inherent value should only be kind of approved. Otherwise, in any case, we have liquidation. So in 53, everything would be settled. Yeah, thank you.
Does it mean, just a minute, sir, just a minute. What you're trying to say, sir, just a minute, please. Just a minute, sir, just a minute. Okay. Okay. If the government dues, according to the government dues, have already been dealt with in 53, they are almost at the bottom. Does it mean they cannot be now considered as secured creditors under 53 and be at top of the board, as has been done in Rainbow?
Yeah, so secured creditor will come in the section 53
No.
in priority, no?
Court said they shall be treated as secured creditors, while 53 said they'll be at bottom of the board. Yes, Abhishek, you want to?
Yeah, so they have created a
I've opened a Pandora box.
No, you have. In fact, in fact, if we see the judgment in Rainbow, the question is framed in para 2, that whether the Gujarat VAT Act will make them a secured creditor or not. So we can't generalize to say, but if we look at any of the acts, whether Himachal Pradesh, whether the VAT Act, everyone have the same provision.
No, but I think if you read, sir, para 53 or 54,
No, I'm coming to that.
draconian one.
51, 52 and 53.
Yeah.
If you read that, it says...
A company has to be liquidated in providing for that.
Adjudicating authority has bound to reject the resolution plan, which does not take into account the dues.
Dues,
But ultimately, we'll have to see whether the question framed in para 2 and answered subsequently has to be seen, and the rest of the judgment, the directions are per
तो
incuriam.
इसका लेके 5% दे दो और वो चल जाएगा. It will be due compliance.
It has to be taken into account whether they are a secured creditor. The question was whether they are a secured creditor, how the treatment is to be given in a plan to a secured creditor. But while doing that in para 51 and 52, they have said that the dues are to be taken into an account in the resolution plan. But if they are not, and you are right, those three words, that government dues, legal authority or any other state government authority, and if they are not taken into account in the resolution plan, the adjudicating authority is bound to reject the plan. Now that will create a situation, and in fact it has already in various benches. They have issued an order saying RP to file an affidavit that the resolution plan, which was heard orders reserved, now to file an affidavit and say it is in compliance of rainbow judgment. So we are in fact waiting that the review come next week or a week thereafter.
Aji, we need to consider it as this judgment passed in Supreme Court in a civil appeal and not under Article 142.
That's right.
Yeah.
No, but sir, in fact, if we read the earlier judgment, which came 2 weeks before it, which was the judgment in ABG Shipyard,
ABG Shipyard, yeah.
same argument under the Customs Act, which is have a paramateria section 11A, was taken, and it is a 3-member bench judgment. This argument of overriding effect was negated. They were treated to be an unsecured creditor, and subsequently a judgment has come which has now created an issue, given I would say a dark rainbow in all resolution plans going forward.
We can't forget Ghanshyam Mishra also.
No, but Mr. Madan, you have to give me permission.
Sir, मैं आपके पास ही आ रहा हूँ मैं. You कह रहे you have to give me permission. आपने कभी ऐसा देखा है? You have to give me permission. No, I'm seeking your permission. You have to give me permission. फिर तो मेरा option ही कोई नहीं, sir, please.
So I just want that the audience, the attention is invited to paragraph 5 of this judgment. And paragraph 5 of this judgment actually is revealing 2-3 facts which are very important. One, that the particular tax dues were pertaining to year 11-12. Second, in 2016, the recovery proceedings started. Third, that in 2018, the assets were attached by an action of the department. When we have assets as attached by way of an action by the department, then we go to the definition of security interest under IBC. Certainly, if an asset is attached, that is also considered as the security interest. And once the security interest is established, then we go to section 53, because the wording there is secured creditor in the first row, after the CIRP and the liquidation cost. The secured creditor means any kind of secured creditor, may it be financial or operational. This is what I wanted to add. This is what I wanted to add.
Okay, that's your view, sir. Because as I said, I have opened Pandora box and everybody is having his views on this.
This is a different fact and it cannot be generalized to my understanding.
Okay. Saurabh, Goyal साहब ने एक और issue raise किया था, objections to the plan. And sometimes you see that some of the creditors who are members of the COC, they abstain from voting. And then they file objections to the plan. Should such creditors be allowed to file objections to the plan unless they have voted against the plan at the time of voting?
Well, I think it's a very pertinent question, Madan Sahab. And I think, as you said, that the law, as far as that issue is concerned, I think is well established, which is one part is the commercial wisdom of the COC, and the others is with respect to dissenting. Of course, there's so much of things to say as far as dissenting creditors are concerned, but I'll take it that way directly itself, because ultimately we have to go at the threshold 66%. That's the law, which is mandated under the code. So as long as, of course, so I think the law there is absolutely clear, which is compliance of the code, section 30, which comes into play. As long as it is in compliance, the plan has to be approved. Yes, but many times, so I really don't think so that there is much scope unless somebody is able to show that the plan is contrary to law or not in compliance with the code, that they will be able to show that whether it affects them directly or whether probably some part of the plan is not in support of them, or maybe there's some part of the plan which probably doesn't suit them. I don't think so that's the intent of the code, number one. And I don't think so that's the commercial wisdom of the COC as well. And I don't think so at that stage, as long as the adjudicating authority consider these 2 points and these 2 issues, that there is much scope as far as interference is concerned. And of course, there has been some judgments to that effect where some part of the plans have been interfered, or maybe there are certain comments with respect to that. But in law, if you ask me, or what probably the intent of the law is concerned, or what probably the commercial wisdom comes into play, there's not much scope as far as those issues are concerned. Yes, there is an issue with respect to abstain. I don't think so there is anybody who would try and not probably in future would like to take benefit that I have not probably voted against it, or I have voted or not, probably I have abstained. I don't think so that benefit would accrue to any one of them, and especially in some cases which we have seen before the adjudicating authority to financial institutions. Now that kind of practice, I don't think so. Probably we would have much leeway to go about it.
Thank you. Makija sir, now I straight away come to section 230. Sir, there is a provision in the code that in case of liquidation, after the passage of this liquidation commencement order, there is a provision under section 230 of Companies Act 2013 that a scheme of compromise or arrangement may be given. There was no clarity in law who may submit this scheme, at what time the scheme should be submitted, whether promoters can submit this scheme or not. Then we had in the year 2021 only, I think, or 2020, Amit Gupta and S. Dhanpal and all that cases, where the liquidators were actually directed to have such an arrangement for the acceptance of those schemes. They should wait for 90 days from the date of passing of the order. It was also said that 29A will not be applicable to the promoters, and the promoters of the corporate debtor can also submit that scheme. Later on then came Arun Kumar Jagatramka versus Gujarat NRE Coke, where it was reversed that the promoters who are ineligible under 29A, they cannot submit a scheme under section 230. And then we saw the amendments in the regulations also. Now, according to you, sir, what exactly is the status that who can submit a scheme? Can it be from the creditors only, or shareholders only, or combination of them? Or any outside party can also submit a scheme? Because recently we have seen some of the newspaper advertisements are coming from the liquidator that anybody and everybody on this earth can submit a scheme under section 230. Is that permissible, sir?
Okay, I think Madan sir, you have raised a very important issue. See, in my opinion, insofar as section 230 is concerned, now it talks about compromise and arrangement under Companies Act. And we have to follow the law which is mentioned in 230. And in 230, there are clear words which are used: creditor, member, or in case of the company which is under winding up, liquidation under IBC also, because those words were added later on. So it can be filed through liquidator. So these are the 3 words which have been used. Now, coming on to this aspect, because there are some judgments, the reliance is being placed on some judgments to say that only liquidator can file. Well, I do not think that, number one, those judgments are really on that issue. That's number one. Number two, in fact, there is another NCLAT judgment which says even the promoters can also file, provided they are qualified under 29A. Of course, that is to be there, but it can be filed by a shareholder, member, or a creditor also, any creditor. Now, one thing which you asked, that if the liquidator is publishing an advertisement, public announcement, inviting 230 from everyone, this is absolutely wrong. This cannot be done. In fact, I have seen certain advertisements which clearly restrict that to the members, creditors, or to these people only. I think that is the correct way of looking at it. Now, one of the important aspects which is there, let's understand what is 230 and why it has been brought in. Well, it's a laudable step. Whether 2B was there or not, according to me, still you could have filed it, whether even Dhanpal was there or whether Amit Gupta was there. Or Amit Gupta was in January 2019, Dhanpal was in February 2019, not in 2020. So 2019. And later on, of course, 2B was brought in. But let's go back to the Companies Act, 56 and 2013. Now, in my experience as the standing counsel for the official liquidator, where we, handled all these things, now the schemes were being filed under 230 in companies which were in winding up. There was no time limit. You could come after even 10 years also and you can say, look, I want to take over the company because this is a compromise or arrangement scheme. The courts were not prohibiting. They said, okay, you file it, we'll call the meeting. Once it is approved, we'll see whether your scheme is valid or not. So this is the same process I think we'll need to adopt here. And number two, under Companies Act, not one judgment, there are a number of judgments. And in fact, that was also been taken care of in NCLAT judgment in Amar Dicam. And they relied upon Megal Homes, which says besides the liquidator, because unfortunately where the confusion is coming. In 230, the word is that in case the company is under liquidation, liquidator will file. So then people say, oh, now the members and the creditors cannot file. No, that's not the correct view. Because if you look at Megal Homes, which is a landmark judgment of Supreme Court, under Companies Act 56, and the same principle will apply. Because the language of 391 and 230 is absolutely peri materia. There is no difference. And that has been recognized in Amar Dicam's judgment of NCLAT, which says besides liquidator, members or creditors can also file it. So therefore, to say that only liquidator will file it, that is not the correct view. But there is one more technical aspect. Fine, scheme can come from members, creditors, and they should file it to the liquidator under Rule 2B, Regulation 2B. Now, who is going to approach the NCLT? Should only liquidator approach, or can the promoters or whatever members can approach directly? Now, this issue is not decided, but according to me, as in Gujarat, NRE Coke also, and in many other judgments, the promoters directly filed. Well, they have to be qualified under 29A first, that's an important issue. But if they are qualified, can they straight away approach? I think this question is yet to be decided by any NCLT or NCLAT. But right now, the view which is coming is that it should be through liquidator, but I do not subscribe to that view. Because according to me, even a person can approach directly. Of course, copy has to be given to the liquidator, and liquidator can examine that. And if he finds any problems are there, eligibility criteria, I think he can have that word.
Thank you. But I think, sir, it should be allowed to anybody. Reason being, under 12A also, if you see 12A read with Regulation 30A, that a settlement or withdrawal application can be filed either by IRP or RP. But in number of cases, we have seen even the promoters or parties to the settlement, they are also filing an application under Rule 11. And those applications are also being accepted subject to that you have paid the CIRP cost. Whatever the IRP or RP dues are there, other costs has been paid, so they are being allowed. And there are divergent decisions on this of Honorable NCLAT also. So here also I think it should be, what is the objective? Objective is settlement, whether A files or B files or C files. Let's not go by the exact language of the law. To the extent the objective of the law is being achieved, I think even the member or creditor should also be allowed to file it. This is my personal view.
As I mentioned, members and creditors are already allowed under 230, but you are saying outsiders.
Outside.
Now, well, you see, I'll tell you, then you will have...
Outsiders are not. Outside, I cannot submit a scheme also, that's what
Yeah, then you should, you are basically saying that 230 should be amended, because if you read the word, it says compromise between the members and creditors. So if it is between the members and creditors and shareholders, the compromise can happen only between these interested parties. It can't be with an outsider.
Compromise. The word is compromise or arrangement. It cannot be with a third party.
Correct.
That's a
Then it's a resolution plan.
That's a fresh proposal. Yes,
That's a
that's a fresh
resolution plan.
proposal only. Okay, now next question to you. Being an insolvency professional liquidator, now according to me, I think I may be wrong, please correct me. There are same timelines for two activities post liquidation order. One is to sell the company as a going concern within first 90 days, attempt should be made. Another is to find out a scheme of compromise arrangement again within the same period of 90 days. So how to synchronize or have a harmonious construction of these two?
It's a very good question, actually, and in fact, I have been, I would say, struggling with this in one of my liquidation cases, and Abhishek is the, kind of proof of that, means he's been handling me in that case. I will just, before answering your question, I will just go back in time in the sense like what Mr. Makhija has talked about in the 230 scheme and arrangement. So definitely, I think one is that settled position that only the members or creditors or stakeholders should be allowed for the scheme. Also for the purpose, one, that it is already there in the Act, in the Companies Act. Two, for the simple reason that it is about a company's confidential information. So if you are allowed anybody outside of the kind of ecosystem of the company, then definitely you are putting the corporate debtor to some risk of any pilferages and something like that. So technically it cannot be done. And now, in fact, when the liquidation regulations has been amended already, and the scheme has to be completed within the initial 30 days of the order of the liquidation. So how will you pass on the information to any outsider? And in this time frame, it is not it's not practically or imaginably possible to have anybody, coming in those 30 days and having the information about the company and, tabling a scheme or propounding a scheme and then getting it approved from the stakeholders. So it is not practically possible. So that question goes away. Now, here comes a very pertinent question. What should be the scheme itself first to be considered by the creditors or the stakeholders? Can any piece of paper be considered or propounded, be taken as a scheme? Because in one of my cases, I'm struggling with with this particular pertinent question, and 15 months in the liquidation already have been passed, and the case has been dragged along from the promoters, from 1.5% of the stakeholder, who's been taken on toss of all the creditors from the long time, that in fact the scheme, like the section 230 clearly says what a scheme should look like what all are the mandatory requirements of the scheme to be tabled. It has to come with the consent of 75% of secured financial creditors. So if that is not there, like with other things like the valuation, the audited books of accounts or the balance sheets and other things like whatever is listed there, so can any paper be considered as a scheme of arrangement or a compromise or not? So in my views, definitely, if the scheme or this plan or whatever you call it is not coming with all the mandatory requirements, it cannot be accepted as a scheme. Now, second question comes to the 29A eligibility, which you definitely dealt.
That question I'm going to reserve for Saurabh.
Okay, fine. Sure. So then if there is anything left there, I would definitely add on there. So 29A eligibility does come here as well. And what will then be, kind of taken as 29A eligibility? Let's sort of speak about that. Now I've forgotten what was your question to me exactly.
What is to be done post liquidation?
Yeah. So the earlier, I understood. So earlier was the regulation was such that the compromise of arrangement also and the going concern also should be considered in the first 90 days. And there was definitely a gray area or lacuna in the clarity of the regulations that which should be the kind of taken or considered. In that sense, if COC, while in the last meeting of its kind of passing a resolution for something, say for example, whether it is a compromise of arrangement or whether it is a company selling it as a going concern or anything. So I think the RP, who is becoming the now liquidator, that RP was there in the COC and now coming as a liquidator in the liquidation, definitely will go by what the COC's past resolution was there. So definitely first RP, who's now becoming the liquidator, and in fact, even the liquidator is a changed person. He has to consider the minutes of the COC, where the decision for liquidation has been taken amongst the secured financial creditors or the COC members. So definitely, when then there is no there is a clear agenda passed in the COC minutes, then definitely RP or the liquidator has to take care of that. But in the case when the liquidation is happening, like say for example, Suomoto, there was no resolution passed in the last COC meeting, or liquidation is happening because of contravention of the plan or plan not getting approved and there was no CIRP left to take any decision like from the COC, then definitely these two things might go together. But now I think we already have that clarity in the changed regulations. So going concern should be the first, say for example, and in any case now a scheme being kind of completed in first 30 days and going concern auction cannot be put in the first 30 days days. So I think it is very, very clear. If in the first 30 days, though no scheme has been, kind of considered, then definitely the company can go into first liquidation. Means the liquidator should go, at least in the first e-auction, should go for the going concern, and subsequent, if that is not, kind of successful, that auction is not successful, should go for the asset sale. So I think my limited view is that.
Thank you. Now the time is running out. Saurabh, last question to you. Earlier, Section 29A was not applicable in case of scheme by promoters, scheme under Section 230 of the Companies Act. Then we had this judgment of Arun Kumar Jagatramka versus Gujarat and Coke, and then we saw the amendments in the regulations. And can you believe that Mr. Arun Kumar Jagatramka has written a book also on this? Yes, he has written also with how he has been treated in this entire CIRP process and liquidation process. What is your view that because under 12A, if a settlement can be given by the promoters only, so whether similar provisions should not be extended here or promoters should be allowed to give a scheme under 230? No.
Well, I think, so I believe, I think this has to be read because 391A, or whether you talk about mega loans as Makija ji said, or you take it the same paramateria 230 in terms of the schemes, and then you take them and apply them in a provision of a liquidation under IBC. The intent as the law which provides when 29A came into picture in terms of the plans under the code, and when you talk about liquidation and you talk about same and read within paramateria with 230 of the Act, but I believe that 29A, I think, is simpliciter, is completely comes into picture. In my view, of course, and as you said that in NRE Coke and Jagatrama cases, the Supreme Court has clearly said, relying on the Megal Holmes concept and as well as the concept even under Swiss ribbons to say that liquidation, even under liquidation, you always try and put the company as a going concern. And that was the intent which brought in even in that judgment also. But 29A, when you talk about, I think as far as even the judgment also of the Supreme Court, even the subsequent judgment in Pawan Bildwell or other several judgments, even of the NCLAT also has clearly held the same, that as far as 29A is concerned 230 probably there's a bar. And the intent probably behind that, for the purposes of bringing a scheme ultimately is the same what we had earlier when 29A's constitutional validity came in and all those issues were dealt with by the Supreme Court. So same issues comes in even in the under the process of liquidation as well. Yes, only one exception, as you said, that what happens, of course, that all right, maybe in several CIRP processes we have seen that there are always changed circumstances, and that's how even 12A was brought in. When Rule 11 was canvassed by the Supreme Court, and then 12A was brought in to say that what stage settlement could take place. And this is one of the scenarios, as you said, also observed, that because in every CIRP there could be processes where even some of the CIRP we have seen EOIs, there are no plans, the promoters are simultaneously trying to settle. And then what happens when suddenly an order of liquidation passed, that whether it can come at that stage. Yes, if you ask me and see the intent of 12A or 11, it can come, but in principally, the code really bars that process as well. The only exception to is 230, which is of course is an exception which is otherwise also considering 29A, not otherwise. So I think there the law is absolutely clear. Of course, we are still, I would always say, as far as IBC is concerned, 6 years is always a nascent stage, and that's Rainbow is an example of that to an extent. And some of the other Vidarbha, we had so many other judgments, but maybe time tested, because in my view, I think 230 is not really tested as of now, frankly, if you ask me. It's neither the regulations, as you said, issues raised with respect to time frame. I think there is something which is required to be done if you want to promulgate or probably, raise the issues of 230 in the liquidation. I think much is required to be done under law as well as under the rules and regulations for somebody as a liquidator to, raise the issues of 230 at that stage.
I really like this term, the law is at nascent stage. Everybody using this term. But when it comes to IPs, then law is not at the nascent stage. He is supposed to be super expert.
Can I just make a comment on that? Please, because I am an exception, I'm not an IP, so I can always make that comment. Well, I think yes, absolutely right to an extent. I think much has been said, and many times these issues comes to me also in several forums that what happens when IP has acted in a particular manner. Of course, we always talk about IP sitting at the top at the helm of affairs as a rainmaker, as I always say, one who's always trying to bring everything and the best of the things for everyone, of course, with a commitment. I always say that as a rainmaker, that he acts as an IP. But yes, I think some of the issues which have been raised or some of the things which has come from the regulators, frankly, much to be desired of. And frankly, there are always extraneous circumstances, because right from, I think we had seen some of the orders which has come in from 2006-17, and now what we are seeing, and there are exceptions to that. I think there's much to be said as far as those issues are concerned. And I think we have to take a larger picture to that aspect rather than going into maybe standardized or generalized principles, which otherwise also in future has changed, if I can say so.
Yeah, just a brief. So there's a basic difference in 12A and 230, because 230 is a compromise and there is a kind of haircut which has been given to the creditors, whereas not in the 12A, so they cannot be put together, one thing. And for the 29A check, there is very important aspect which needs to be seen by the courts, or when the 230 scheme is being propounded. That if the company has been taken into insolvency in the section 10 only, and before the section 10 application also the company was in the last 4 years in the BFIR. So after the 4-5 years in the procedure in the CIRP and the liquidation, can one fine day up 1% or 1.5% stakeholder come up and say that I want to file the 230 scheme, who's the son of the MD of the company who made the company to this level? So I think these aspects has to be seen into in conjunction with everything together, because even if the 29A applicability is there in 230, so one more aspect that the only 230 like the aspect of 29A is not seen in the case of MSME, and if the company is not the MSME, and even if the written down value of the assets or the investment in plant and machinery has been there, still you cannot be an MSME in, just because there has been some judgment in some other case who has been given if you are eligible to be. So the eligibility for MSMEs also has to be seen into, kind of into a 360-degree view, and not just one judgment should be precedented to any other case. So every case has to be seen case-to-case basis, and then only the jurisprudence should come. So that's my limit. Thank you.
Take a note of subject to just exceptions. Over to you, my dear Abhishek. Thank you very much, everybody. Thank you.
Thank you, everyone. I hope that we have not kept you too long waiting from the lunch. And from this session, I think that we still have the Pandora box open, and we still need to get the answers, I think, sooner or later, once these judgments probably, which we were discussing today, comes to, I think, a review or probably settle down. And I think the issues of 29A will still go on. And I would say, take the comment of Saurabh that it's at the nascent state. I would say it will still go on till the IBC is going on. So it can't finish.
Thank God you are saying till the IBC is going on.
Yeah. So 230 scheme, when there was no 29A only. So that is what not envisaged. 29A came only in IBC.
That's right. Yeah. So in fact, I will not dwell upon any of the issues raised. I am just now...
Yes, please. There is solvent company. तो फिर liquidation में क्या कर रही है वो?
But there is some dispute between the applicant and the CD. Dispute or not on record, so it may be admitted also. Can the COC decide after formation of COC that settlement plan with the promoters without going in through CRB process?
Okay, the section 12A is applicable because 12A also allows that even 90% of the committee members, in case they agree to take 50% or 40% or 90% of their claims, still 12A is possible. However, in 12A, only the creditors who agree to this, other than the 10%, because he will be dragged in, all other operational creditors and no other liability would be waived. With the company will, just only 12A means the CIRP is withdrawn and it will not be considered as Section 53 is not applicable on 12A. So no other waiver, no other operational creditor, no government authorities would be waived because it's just a withdrawal. It's just a withdrawal. So the COC can decide 12A at any kind of haircut, but that doesn't mean that other applicable provisions would also act here in this case. It will not,
There is
because no other
haircut.
waiver would be
There
there.
is no haircut in this proposal. We just want to pay the.
गोयल साहब लंच पे करते हैं ना डिस्कस प्लीज हाँ खाना खाते हुए
So I thank everyone and please join us for the lunch.
If you permit me, there is a query from my side.
डॉक्टर जतिंदर
Yes, Dr. Singh.
Thank you very much. In fact, let's have a big round of applause for all the panelists. And special thanks to Mr. Madan for moderating the session. So I was just sitting there, I was feeling he was just not a moderator, but also devil's advocate, right? Because he was just provoking everybody to, come out with some of the novel ideas and solutions. Thank you very much for this indeed. And I will request Mr. Madan and Mr. Abhishek to kindly come forward and please felicitate our panelists with a small token of gratitude from PhD Chamber. Thank you, everybody. And ladies and gentlemen, in fact, we'll be coming out with the report of this conference with all list of recommendations. We will send it to you also once the report is completed, and we definitely look for some of the recommendations from your side also. Thank you very much. Thank you indeed.